To order, and clerk will open the roll. Oh, sorry. Mr. Chair, you have quorum. He's stuck in traffic. All right. First of all, a couple of items. The House Bill 1979 that has attracted some attention is going to go by for the day. I talked to the patron yesterday. I apologize for any inconvenience that this causes anybody who is here. That will be taken up on Wednesday. Before you on the dais are lists of judges who have been interviewed, who are before the Senate for appointment to various positions to the Supreme Court of Virginia, Circuit Court, General District Court, and Juvenile and Domestic Relations Court. These interviews have taken place, and the list of candidates to be certified are contained in these two letters. Does anybody have any questions about the list that is before you? Hearing none, is there a motion to certify the candidates on these lists? It's been moved and seconded. Roll is open. Ayes 12, no 0. All right. Anything else? All right. No, hey, Shannon, I think she's gone. That was, Hobie, that was for both lists, all three or all four. Okay. That certification was for all, the Supreme Court, all three lower courts. Okay, thanks. All right, next on the list we have Delegate Peace. House Bill 1911.
Thank you, Mr. Chairman. I think I may also have 2016, but want to do
You want to do that first? Well, let's do 1911 first.
Yeah, let's do 1911. Thank you, Mr. Chairman, members of the committee. So the bill that you have before you is a simple bill in structure, but profound in impact. Those of us in the Hanover community will recall the tragic events of October 2018 when we lost Lieutenant Brad Clark, who was a dedicated member of our fire department. His tragic death has highlighted the problem that we now see across the roads all over the Commonwealth, and that is individuals who are failing to move over or slow down adequately to give way and create safe environments for our first responders, firefighters, EMS, towers, and others, state police in particular. Since that time, we've also seen an increase in these incidents, these accidents that relate to failure to move over. In fact, one day in December, there were 4 state troopers who were rear-ended. The bill has been unanimously supported to this point. We have a great deal of support here in the room, and I think it's probably best to let those individuals who've come here speak to why we want to true up and streamline what is existing law. The point I've made previously is that on a first offense, it's a $250 traffic fine, and second offense is reckless. And so from our perspective, we want to streamline that failure to move over, slow down safely is reckless, regardless of when it happens, not just on a second offense.
Delegate, yes, thank you for bringing this bill. This is an issue, and certainly the events that triggered the filing of this bill are heartbreaking, and members of the committee are very familiar with it. This bill has received a great deal of discussion. We use a time clock here, yes, just because of the large number of bills, and I want you and your witnesses to understand that applying that is in no way any indication of disrespect or lack of consideration for the seriousness and the tragedy involved. So,
Senator, thank you, and I informed those here to support the bill
Mr.
of
Chair.
that, and I appreciate it.
Mr. Chair,
Senator Peterson.
Delegate, and I actually remember this bill was originally brought by Delegate Melanie Rapp in the House many
believe
years ago.
she's here today.
And I know she is. Let me ask you a question. In a lot of the highways in my part of the state, it's pretty crowded in the traffic lanes, and it's not feasible to move over. Can you talk about what the standard of care would be, where, again, you have a car in the breakdown lane that's got flashing lights, and you're in the right lane adjacent to it, but you got passing traffic? How do we judge what's the right or wrong response there?
I think, Mr. Chairman and Senator Peterson, let's just go to the bill itself. The substitute that came over in Section A, it talks about on a highway having at least 4 lanes, at least 2 of which are intended for traffic proceeding as the approaching vehicle proceed with caution, and if reasonable, with due regard for safety and traffic conditions, yield the right-of-way by making a lane change into the lane not adjacent to the stationary vehicle, or if changing lanes would be unreasonable or unsafe, and that may be, to your point, Senator Peterson, proceed with due caution and maintain a safe speed for highway conditions. And so that would address that concern or question.
Mr. Chairman?
Senator Edwards.
I have a technical question on lines end of 23 to the end of 28. Seems to me you have 2 sentences that are duplicative. One is your license can be suspended for 2 years if you injure somebody, and then the next sentence, if there's a death, the same thing, 2 years. What's the difference? I would think that the death would be something slightly different than the injury in terms of, because both say your license is suspended for 2 years.
I believe, Mr. Chairman, I think it says, at least in the substitute that I have, talks about for damage to property for not more than 1 year, and then in the second sentence, it talks about for not more than 2 years. So I think they actually...
Well, maybe I do have a substitute, but it's 2 years for both death and then the next sentence, the previous sentence, 2 years for injury. Is it not that, what am I missing here?
Steve.
Mr. Chairman, that's current law.
Yes.
And what this bill does is repeal current law and substitute the new language, but it has picked up the same language existing in current law, 2 years for injury, 2 years license suspension, also for death.
So I guess what Senator Edwards is asking is, should it say
Death or injury.
2 years for death or injury?
I would consider that a friendly amendment.
Yes.
I move combine the 2 sentences into one and say death or injury.
Thank you, Senator. Thank you.
All right, is there a second to that motion?
Mr. Chairman,
Okay, Senator McDougal.
but that is, Steve, that's the way it is today in the statute. And so the way the House substitute did, it moved it out of the current statute into a different section. Is that accurate?
Yes.
And so because all this language is italicized, it doesn't mean it's new language. It just means it's in a new section, but old language.
Almost. Some of it is new. That's the point of the bill. Under the current language, a first offense is a traffic infraction. Under the bill, the first offense is reckless driving, a Class 1 misdemeanor. There are other nuanced changes, but that's the essence of the bill.
I think what Senator Edwards is asking is, for sake of clarity, if I were to be reading those 2 sentences, I might spend a little bit of time trying to figure out what the difference is. Charles?
Mr. Chairman, there is a distinct difference between the 2 of them. Okay. Looking at line 25, it does say for no more than 2 years for a person injured, while death is for 2 years.
For 2 years. Okay.
But it says may, too, in both categories. There's a may.
But this second sentence is essentially the equivalent of a mandatory minimum for 2 years?
Except that it says may,
Steve?
Mr. Chairman. It doesn't say shall.
Mr. Chairman, Senator Edwards is correct. It is may, it's permissive, not mandatory. And so although for death it says 2 years, it still says that the court may suspend for 2 years.
Mr. Chairman, to Senator McDougal's point, the old statute is repealed in the bill, which was 921.1. We did lift and move to create a new 861.1. So that's where the second enactment clause repeals that.
All right. Do you object to that amendment?
I don't object to it. I consider
All
it a
right.
friendly
It's
amendment.
been moved and seconded to amend to combine those two sentences. Steve?
And will that amendment be for up to 2 years, or?
Which is my understanding as to the meaning of those sentences now, right?
Well, I don't know if they intended this, but what it currently provides is that if the court decides to suspend for death, the suspension must be for 2 years.
Well,
And that could be counterproductive, and so it's probably better to say up to 2 years.
And that was what I had heard the senator wanting to make
Yeah.
the change to, and that's fine with me.
yeah, yeah.
Up to 2 years is fine with you? Okay. Motion has been made to make that amendment. All in favor signify by saying aye. Aye. All opposed? Amendment is adopted.
We have a few folks who would like to address the
All right,
committee.
Senator McDougal?
I did think that the committee needed to hear from Ms. Clark.
Yes.
And for the members who don't know, is Ms. Clark's husband, Brad, who passed away that night.
Welcome, and we're so sorry for your loss.
Thank you. Good morning. My name is Melanie Clark. I am the widow of Lieutenant Bradford Clark. My husband was killed 4 months ago today because a motorist failed to move over. I, along with many others, are here today in support of House Bill 1911. To help you understand the depth of my support for this legislation, I must tell you about my beloved and devoted husband. Brad was a lifetime resident of Hanover County. He served as lieutenant for Hanover Fire EMS. He was fiercely loyal and a mentor to everyone he met. His passion for his career in the fire service was unmatched. Brad was a fireman's fireman. Brad was deeply committed to the safety of citizens he served and the firemen he trained and led. His dynamic and compassionate personality affected thousands from all over the country who are now mourning his loss. Brad was struck and killed by a tractor trailer while responding to a vehicle emergency on Interstate 295 during Tropical Storm Michael. Brad was credited for saving the lives of his crew during the incident that took his life on October the 11th. With little time and a tractor trailer barreling down on them, Brad warned his crew of the oncoming danger. His actions saved their lives and cost him his own. 2 of his crew members received life-threatening injuries in this incident. Our family's lives are now forever changed. Since my husband's avoidable and untimely death, there have been multiple accidents involving public safety officers, tow truck drivers, and VDOT crews here in Virginia, along with many near misses. Being struck by a moving vehicle while working on roadways were the single leading cause of officer line-of-duty deaths and the second highest cause of firefighter fatalities nationwide. Nothing can bring my beloved husband back to me and our girls. I can only hope by bringing awareness to this legislation, I can save another family from the devastating loss my family has endured. Going forward, we can make the commitment to bring about change and awareness to the epidemic of distracted driving and the failure to move over. The increase of accidents makes our firefighters, police officers, tow truck drivers, VDOT highway workers, and all drivers and passengers extremely vulnerable. Public safety officers have repeatedly expressed their concerns to me of dying in the same manner my husband did. They fear they will not come home to their families because of the increased life-threatening dangers that exist while working on highways and byways. Our public safety officers risk their lives every day by serving and protecting us. We must do a better job of protecting them. It is now my life's mission to bring awareness and education to the Move Over law. The time is now for change. I am requesting your support for House Bill number 1911. This is one way to bring about awareness to this seemingly ignored law. We are asking you to support House Bill 1911 as written and unamended. Bill 1911 passed unopposed in the House of Delegates with bipartisan support. This legislation protects all of our firefighters, police officers, tow truck drivers, and VDOT highway crews who work on our roadways every day. This is a common sense proposal that will cost little and save so many precious and invaluable lives. How many families will needlessly suffer the loss of a family member before stiffer penalties and fines are imposed to violators of this law? The public safety community, tow truckers, and VDOT workers support this legislation. Please do your part in protecting the public safety officers who willingly put their lives on the line for you. This proposed legislation not only serves to protect our public safety officers, but all of our family and friends who drive Virginia's roads and highways. Thank you.
Ms. Clark, thank you for being here and for your advocacy. I know it's not easy. Just please know that members of the General Assembly, particularly members of this committee, just really appreciate it. And I just pray for peace and comfort for you.
I appreciate that. Thank you, sir.
Mr. Chairman, good morning. Wayne Huggins, representing the State Police Association. 5 names, only 5. There are more I could mention. Trooper Jessica Cheney, hit and killed on Route 1, investigating an automobile accident. Trooper Robert Hill, killed on Route 58 while assisting a motorist. Trooper Jacqueline Vernon, hit in Arlington by a Metro bus, killed in the line of duty. Trooper Harry Lee Henderson stopped a violator on Interstate 66 in Clark County, was hit and killed. And one of my shift partners, Trooper Jim Hughes, hit and killed on Interstate 95 at Lorton, June 3rd, 1974. One of the things about the tragic incident that took Lieutenant Clark's life is there were 2 other firefighters that were hit in the same incident. One of those is a son of a trooper also. So all of these events have enormous impact upon us, and we completely and heartily support this legislation. Thank you.
Thank you.
I'll be very quick. Aaron Rice with the Virginia Professional Firefighters. We do support the legislation, as Ms. Clark so stated. Thank you.
Thank you, Ms. Rice.
Mr. Chairman, members of the committee, Nikki Zamosny, Assistant Secretary of Public Safety and Homeland Security, and the administration supports this bill.
Thank you.
Good morning. Kevin Morris, Hanover Professional Firefighters. I rise in support. And I would also like to ask everybody here that in support of it to rise.
Thank you very much for being here. Your support is duly noted, and we are very sorry for the loss of your comrade.
Mr. Chairman, Ed Rhodes with Virginia Association of Rescue Squad, EMS Administrators, Regional Directors, and the Virginia Ambulance Association. And also standing beside me is former Delegate Melanie Rapp Beal, who was the patron of the original bill. And all the groups I just mentioned support the bill fully.
Thank you.
Thank you.
Good morning. Bruce Eagle with Eagle Towing, Chesterfield, Virginia. On behalf of the almost 7,000 towing company operators, tow truck operators in Virginia, we support this bill as written.
Thank you.
Thanks, sir.
My name is Floyd Mays, and I'm speaking in support of the bill. You know, I had a flat on the interstate. The car in front of me had a flat, kind of blew up. I picked up some debris, didn't know it. Around milepost 195, went flat. I pulled over on the side of the road, Interstate 64, and I was about to get out of my car. I could not believe how fast and how close the traffic was coming as I needed to change this tire. I got back in my car, called my office, and said, send me a tow truck out here. I'm a pretty independent guy, but no. And while the tow truck guy is there changing my tire, I'm like standing on the side of the road because it's just unbelievable. When you're parked, I didn't even want to sit in my car. And these other vehicles coming, I think the speed limit there is maybe 65. And, you know, 65 is pretty fast. And some are going a little faster.
Thank you, Mr. Mays.
And it's, you know, we need to have some deterrent to get people in the frame of mind to give us a little more space when we're out there.
I think folks
Thank
are
you.
headed in your direction.
Thank you.
Good morning. I'm John Mahoney with the Virginia Association of Commonwealth Attorneys, and we support this bill.
Thank you.
Thank you for the extra time. No further comments.
Any discussion first? Does this need to go to finance? All right, the motion is to report and re-refer the bill as amended to the Committee on Finance. Cast your vote. Ayes 15, no zero.
Thank you, Mr. Chairman.
Thank you, Delegate, and thanks to all of your advocates who are here. Congratulations.
May need to come to one more meeting, Mr. Chairman, so I'll be in touch with them.
Next bill?
House Bill 2016. This is a bill brought by a constituent in New Kent County, Mr. Chairman, members of the committee, requiring the Department of Forestry to convey a right-of-way easement perpetual cross.
Chris, I don't think
portion
there's
of-
any problem with this bill.
Okay.
Kristen, good shape? You aware of any opposition?
I'm not.
Anybody in the
department
audience
supports the
wish to express any opposition to this bill? All right, the bill is before us. It's been moved and seconded. The bill be reported.
Thank you, Mr. Chairman.
Thank you. Next, Delegate Byron. Right.
Thank you, Mr. Chairman, members of the committee. House Bill 2542 is the Safe Families Bill. You had a similar bill to this last year, and I appreciate you taking it this morning. I understand there was a mix-up with the bill numbers, but I did
It's
have
on the
somebody get
public
up at
docket.
5:30 to be with us today and drive in from Lynchburg. This successful program that has been working very well, not only in Virginia, but over 100 chapters in 41 states. Our group, to summarize, got together with family law and the bar and social services to address some of the concerns that the chairman indicated last year when we came before you. And what you see in front of you in this new version of the bill is an agreement between all of them in regards to those concerns and putting things into place that would provide the additional oversight, I believe, that you were looking for. But if you would please hear from the gentleman that came, I would appreciate it. Thank you.
Sure. Welcome.
Thank you, Mr. Chairman. Members of committee, thank you so much. I'm with Patrick Henry Family Services. We've been privileged for the last little over 2 years to be able to do operate a pilot program for safe families here in Virginia. And the pilot program has been going very successful in our area. And we've had the opportunity to serve just under 100 families. And many of them were on the edge of care. And we've had the opportunity to really be able to divert them away from the foster care system and provide some wraparound services. What I'm pleased most about this program is it's been well proven for over the last 15 years, serving in over 41 states. We've had over 41,000 hostings nationwide. In the state of Illinois, it's actually become part of their diversion program to help keep children out of foster care and provide those wraparound services ahead of time. So it's very much a preventative program, and we've had great success here. Many of the children and families that we've served were on the edge of care. On the average, somewhere between, 50 and 52% of the children that go into foster care do not return back home. 98% from the pilot program over the last 2 years, 98% of the children have been reunified back to their families in a stronger home. And those relationships continue to be strengthened. And so we've had an opportunity to sit down. Last year, we knew we had a little opposition because there was a concern that there wasn't enough accountability. We've been able to sit down with the Family Bar Association and be able to really work out some of those details to, I believe, provide a bill this year that can really be a benefit to the children and families in Virginia.
Well, thank you. Kathy, Department of Social Services here?
Mhm.
Morning, Mr. Chair.
Can you tell us what your position is on this?
Sure. I'm Carl Ayers, Director of Division of Family Services. Have been working with Delegate Byron and Patrick Henry Family Services now for about 4 years on this specific legislation. And I think where we are this year is it is now in a licensed child placing agency, which has been the concern in the past years, is there was no actual entity for oversight if it went through as far as that goes.
So you support it?
I don't have an official position from the administration on it, from that piece of it. But as far as everything goes, I can tell you on behalf of the department and overseeing the pilot, there's no concerns with the operation of it.
Fair enough. Anybody here in the audience who wishes to speak in opposition or express concerns about the bill?
Mr. Chair? Oh, I'm sorry.
Step right up, yes.
Mr. Chairman, I'm Scott Price. I'm here representing the Organization of Virginia Homeschoolers. My client likes this bill very much, so much so that they want to make sure that
You support the bill?
We do support the bill, sir. So much so that we'd like to make sure that it extends to families that homeschool in Virginia. Right now, the bill
Have you worked with the patron on this?
I have spoken with her office, and I spoke briefly with the patron. What we are looking for is a very small line amendment that doesn't affect the major parts of this bill, but that would put homeschooling families in the coverage of the bill.
Delegate Byron, have you seen the amendment?
There was an amendment brought at the very end in the House, and I said, let's wait till we get to the Senate. My concern is we've been working so hard. I didn't want anything to interfere with the passage of the bill, so I was hoping that the gentleman would get to speak to some of the Senate members. I have not been able to.
I think that this has been scrubbed, and there are few people who are more sympathetic to homeschoolers than Delegate Byron and many of the members of this committee. However, I would be concerned about introducing new concepts into the bill now. I would expect that Delegate Byron would be happy to work with you over the course of the next year.
I would absolutely be very delighted to do that, and I'm sure Mr. Neff would as well.
Certainly. Thank you, sir.
All right. Delegate Peterson, or Senator Peterson.
Either one.
Gosh.
Yep, my question is more of a practical one, Delegate, and that is, what situation are we talking about? Are we talking about somebody having orders and going overseas, somebody, a parent being incarcerated? I mean, what circumstance are we addressing here?
Do you want to address that? I have a lot of different examples, but
Okay.
Mr. Neff has been managing it for the last several years. I'll let
Sure.
him speak to that.
Yep.
Or you can.
Yeah, I'll speak to it. Mr. Chair, Senator Peterson, both of those and many more from that end of it. What it is just that temporary situation where the child cannot stay with the family and without having to actually bring them into foster care. There is a process in foster care that's called the temporary entrustment that allows you to do something very similar to this, only this process takes it completely out of that and uses it more from a community support instead of bringing it into foster care.
One further follow-up question, Mr. Chair. And how would this be different from a legal guardianship under 31-4? Is it just a sort of a step down or a non-permanent step?
It is a non-permanent step, and it is actually time-limited. So it's specifically time-limited as to the time that it can occur. So it's 6 months or shorter unless it's somebody that is going overseas, to your example, then it could be a year. Or until they come back, there's actually an exemption in there for if they are deployed for longer than a year, they have to come and get their child whenever they return for military families.
All right.
All right. Any other questions of the patron?
Mr. Chair,
Senator Deeds.
in reviewing this legislation, is there any court review of the power of attorney? Is there any way to protect the best interest of the child?
Well, the parent has control over that power of attorney at all times, is my understanding. Now, is that correct?
It can be
Mr.
revoked
Chair,
at any
Senator
time.
Deeds, yes, there's no specific for this to go into court. If it goes longer than court, then the process, that's whenever it comes and is overseen by the court and moves forward from that end of it. And for further clarification, for the temporary entrustment that occurs now, you have to go to court within 6 months of that child coming in. So even if the child comes into us for temporary entrustment, that you don't actually go in front of the court system until 6 months. So we've worked very closely to make sure this mirrors the process that already exists for the foster care system, provide the same protections.
All right.
Mr. Chairman, the other thing I'll just say very briefly, the thing that's very unique about this too, I think, is that it allows the child to be able to say if they're in school age in the same school district, be in the same familiar areas of that their life was before. And in many cases, the parent is even being hosted by the family as well. So they have a complete family environment or an opportunity to stay in an environment that replicates what they had.
All right, any other questions? Family Law Coalition here, have any concerns? Y'all good with this? All right. Bill is before us. There's a motion to report the bill. Is there a second? Hang on just a second. Kristen, Steve, any amendments necessary that, I mean, I looked at the comment about the background, and I think given the two sentences in there, it's pretty clear that the first reference to background check refers to the organization, and then later in the paragraph, it has a background check requirement for the family. I mean, I'm not. Steve?
I don't disagree.
Okay. Just want you to know I actually looked at your concerns.
Read the comments.
Senator Sturtevant.
The person being delegated the authority has to go through the background check requirement, but in a foster care situation, would everyone in that household have to go through would they all get checked out? And is that a difference here?
Yes, Mr. Chair, Senator Sturtevant, same process as you would if it were in foster care. It's all the adults that are in the home that go through the background process.
How about this? It seems to me maybe Delegate Gilbert carried a bill last year that required the background check for the child being placed. Does that apply here too?
Mr. Chair, and Delegate Gilbert can certainly speak to his bill from last year, but that was in regards to providing all reasonably and ascertainably known information to the potential foster parent about the child from that end. It wasn't a background check, but it was provision of information.
All right. Okay. Well, the bill is before us. Senator Chafin made a motion to report. Is there a second? All right. It's been moved and seconded. The bill be reported.
Ayes 14, no zero, abstentions 1.
Thank you very much.
Thank you. Next, we have Delegate McGuire.
Good morning, Mr. Chairman, members of the committee.
2044, good morning.
So this bill makes it so medical subpoena compliance timeframe by healthcare providers can be extended an additional 7 days upon written request to the party requesting the subpoena. This is provided that the subpoena was received, served within 15 days of the return date, and that the additional time does not adversely affect timely prep for trials.
I got a couple of questions for
Sure.
you. You know, these, first of all, under current law, there already is a time period that is required to be given to medical providers in order for notice to go to the person whose records are being subpoenaed. So they already have a statutory period, grace period, before they are even required to start producing those records. Lawyer has to certify at the end of that statutory period that there's no objection that's been filed, no motion to quash. What your bill does is it says that they have to ask, the healthcare provider can ask for an extension, which the lawyer issuing the subpoena can't unreasonably object to. I mean, first of all, and I mean, well, I do mean a little bit of harm to your bill, but nothing personal. You know, that's basically what happens anyway. If a healthcare provider, well, I'll tell you what happens anyway, is the healthcare provider just ignores the deadline.
Mm-hmm.
And they get around to producing the records when they're darn well good and ready to produce the records. Occasionally, the healthcare provider will call and say, we need some extra time, in which event the lawyer says, well, of course, because the lawyer isn't going to haul them into court and try to sanction them. All they want are the records.
Right.
It is becoming darn near impossible to get particularly many hospitals to comply with subpoenas and record requests in a timely manner. And, I, for one, just think that this is just going to tack on an additional, 15 days or whatever to the standard time for production of these records. And, I, for one, have great concerns about that. I think it slows down litigation.
Well, so the problem came to me from several lawyers in my district, and they said the magic number is 15 days. But because of mail, people sitting on their desks, et cetera, people get the paperwork and they have to jump the hoops and they can barely make the time frame. So this is permissive, and that they can request the extra week.
Mr.
So
Chair.
they can already do that, though, right?
Mr. Chair,
Senator Peterson.
would you accept a friendly amendment that they shall not charge over 10 cents per page copying cost?
I do like that. I do like that.
If you do that, I'm going to be a co-patron. We're going to hand this thing together.
I move the amendment.
I move the amendment. Anybody want a second?
I second it.
All right.
All right, motion's been made. Is there a second to the amendment?
Second.
It's been moved and seconded. All in favor signify by saying aye.
Aye.
All opposed? All right, bill is amended.
Do you
Move
want
to report.
Do you want to strike your bill?
I don't want to.
I'll second
Move to
the
report.
motion to report.
It's been moved and, first of all, anybody here in support of your bill? As amended? Anybody here in opposition? Scott loves it.
Scott just had a heart attack. Someone get the defibrillator.
Mr. Chairman,
Kristen.
may I ask a question about the amendment? Right now, those fees for copying are found on lines 73 through 86. There are different fees depending on how many pages are copied. Is it 10 cents across the board? Is it 10 cents up to 50 copies? All right, thank you.
And that is if the permission is granted. Okay. All right, Scott, you love it?
Good morning, Mr. Chairman. I appreciate all the attention and support here. We did not request this bill, so I'm not speaking that we'd ask for an introduction of it, but obviously with Senator Peterson's amendment, we are now opposed to this bill. So.
I thought that the amendment could be even better, that if they wanted to ask for it, they have to produce them for free.
I move that.
But anyway, all right, the bill is before us as amended. It's been moved and seconded that the bill be reported. Roll is open.
Ayes 10, noes 5.
Thank you, Mr. Chairman.
Don't say it unless you mean it. I'm sorry. All right, we've got Delegate Adams next.
Good morning, Mr. Chair, members of the committee.
Delegate Adams, welcome. You've got House Bill 1742, which I gather is virtually identical to Senator McClellan's bill.
Yes, sir.
I think that our inclination would be to conform and report your good bill. So it's been moved and seconded that the bill be conformed to Senate Bill 1108 and reported. The roll is open.
Ayes 15, no 0.
That was easy.
Thank you.
All right, next, Delegate Rob Bell.
High-five Delegate Adams, but somehow she chose not to high-five me.
Mhm.
All right. Mr. Chair, I have three measures. One is a measure which is a subpart of one of the bills that the chairman had, and it went
Which is a great bill.
Well, but it went out of this committee, went upstairs, and did not leave the Senate. And
All the more reason we need to report yours.
oh, I was going to take it the other way and say I'm aware that this is that time when we have.
I think it's, hey, I have no pride of authorship. I'm delighted that you brought the bill, and yours
understanding
may
there's-
actually face a different
Understanding that
phase.
there's no commitment in the
Which
Finance
bill?
Committee. It's 2586. It's a subpart of the Crime Commission recommendations. We broke it into 5 bills that are working their way through your committees. Your omnibus bill, again, went up to Finance and did not make it out. So
I
if you're
think-
trying to track the same track, that we go to Finance and then perhaps.
Unless anybody has an objection, my hope would be that the committee will report and re-refer 2586 to Finance, given that in substance it is the same as a bill that has already reported from this committee.
Mr. Chair?
Yes.
I apologize for sort of slowing down the train here. What offenses are we adding to registration, just so I know?
Well, the offense, what we are doing is we are creating from Class 1 misdemeanors, we're making Class 6 felonies out of 2 of the charges that are benefiting from the child prostitution. So we already have the core human trafficking, we already have the core pimping, if you will, but the other 2 charges that we currently have as Class 1 will be raised to Class 6 felony.
Okay. So
And then the
what
other-
exactly are they? 348 and 349?
Yes, sir. One is.
What are they?
The vehicle, one is the transportation/vehicle, which is the 349.
Aiding in prostitution,
And the other is the
348.
aiding. It does not change the body place. But
Okay.
those are the 2, 348 and 349. So any agent who, with knowledge of good reason to believe of the immoral purpose, takes, transports, or assists in taking, transporting, or offers to take or transport the person. So the people that drive the child prostitute to the scene, drive them out to the
Okay, so just,
liaison.
Mr. Chair, if I might.
Sir Peter.
And I track these pretty closely because there's been a lot of mission creep on this statute. Someone who drives the vehicle that is related to prostitution, as well as someone that rents the property, are now caught up as registered offenders.
Certainly the vehicle would be.
You said body play, so
I
I
said
would
that,
take.
no, but I said that was not being impacted by the felony statute. Now, was your question for the, was your question about just the registry or where we're changing the conviction level?
No, all right, that's fine.
Because 347 is the body place, the person that rents out the place. That's not being impacted by the felonization of the other parts.
All right, anybody here in opposition to this bill?
Mr. Chairman, move the bill be reported and referred to Finance.
All right, it's been moved and seconded that House Bill 2586 be reported and re-referred to the Committee on Finance.
Ayes 14, no zero, abstentions 1.
Mr. Chair,
Sir, Delegate Bell.
I respectfully ask the committee to consider House Bill 2239. That's a small bill.
This bill deals with the Albemarle County Courthouse.
Yes, sir.
Provides that even though it's in the city of Charlottesville, that offenses occurring in the actual courtroom are within the jurisdiction of the county.
The goal is to co-locate the district courts for the county and city. There's a law about it being fee simple for the county courthouse. They have a property. We actually did not, there was some dispute, but we did not want them to leave Court Square, but they've got a place in mind, and it would be an efficient use of the space. And if you've practiced in our circuit court, you understand why the circuit court needs to get a little bigger. They're going to take the old district court.
Aware of any opposition to this bill?
I'm not aware of any, no, sir.
Anybody here in the audience in opposition to the bill? Any questions to the patron? Senator Stewart moves, Senator Sasslaw seconds. Motion to report.
Ayes 15, no zero.
All right. Next bill.
Mr. Chair, House Bill 1941. For this, I do have a couple of witnesses. So if you want to start our clock.
Okay, 1941.
Okay, so, Mr. Chair, members of the panel, this is a bill that, as we sometimes see, technology moves in positive ways and does amazing things, but sometimes the law we need to consider legal adjustments to it. And it was in 1997 we created the DUI maiming statute. Most of us understand that we were further back, people would be in bad accidents and die, and it was covered by manslaughter statutes. As medical technology got better and people were surviving the crash but having severe injuries, we wrote the maiming statute. That was before my time, but that's my understanding of the purpose of it. What we now have is the wonderful advances in medical technology have enabled people in very, very severe drunk driving accidents to survive without the level of injury required by the current statute, which requires that for it to be a felony, the injury must result in permanent and significant physical impairment. So, Mr. Chair, with that as the backdrop, I'd like to introduce you to a family from Fluvanna County, also constituents of Delegate Senator Peake, who just stepped out. Who's going to tell you about an accident involving their daughter. A very happy story with how well she recovered. I have some photos, but it also impacts our thoughts about the statute.
Great.
Mr. Chairman, thank you.
And Delegate Bell, before your witnesses step
Yes, sir.
up, are you aware of any opposition to this bill?
I am not. It is changed. It's a policy decision to change where we
understand.
cite the felony line in our DUI laws, but I'm not aware of any, no, sir.
Okay. All right, we'd be happy to hear from your constituents.
Thank you. Mr. Chairman, members of the committee, I'm Jeff Hayslip, Commonwealth's attorney from Fluvanna County. I'm here speaking on behalf of Virginia Association of Commonwealth's Attorneys. We do support this bill, but I'm also here with the family that Delegate Bell mentioned. Where we see the hole in the law that this bill is trying to fix is when DUI crash cases come to Commonwealth's attorneys, they're almost always charged as misdemeanor DUIs because the injury can't be determined at that point in most cases to be permanent and significant. So the charge is a misdemeanor DUI. The victim in the case who has serious bodily injury goes through rehab, physical therapy, and all these things for months while the Commonwealth's attorney and, frankly, defense counsel are trying to get an opinion from the doctor whether these are going to be significant and permanent injuries. The case languishes. The victim's family and the defendant both have to wait for months for the case to go forward. This accident took place in November of 2017, and this case is set for trial in July of this year. And that's the delay that these things cause. This bill would acknowledge that when someone chooses to drink and drive and they crash their car into another vehicle or person and they cause an obvious serious bodily injury, that it can be charged as a felony at that point and not have to wait often months and months until we can get a doctor to opine as to whether, if ever a doctor will opine as to whether these will be significant and permanent injuries. I want to stress this bill does not apply to any bodily injury. It is just serious bodily injury. And with that, I'll introduce you to the Petrolax for Fluvanna County.
And just so I understand, and for the patron, for counsel, and Commonwealth's attorneys, so currently the voting DUI is only if it is permanent and significant physical impairment. What this does is creates Class 6 felony for serious injuries, so you don't have to wait, find out whether it's permanent, but a Class 4 felony for essentially the conduct that is already the felony offense, the serious, significant, and permanent injury.
Yes, sir.
Okay.
And you said voting. While we were keeping them parallel, certainly the bigger and more common will be the straight driving on a DUI.
Mr. Chairman?
All right. Senator McDougall.
Maybe this is for Rob or for Steve. Can you refresh our recollection on what constitutes serious bodily injury? Is a cut, breaking of the skin going to be?
That would be simply bodily injury. This law does not go that far. There are other definitions of serious bodily injury in the code, and the one I have it's from 16.1, but it says a serious bodily injury means, quote, any bodily injury that involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or mental faculty. Now, I will tell you that is not from the criminal code section. The criminal code section generally says bodily injury, which, as you say, is a busted lip, bad black eye, and then, or the additional language at the end. And what the pictures that are going around, the reason that what happened was she was almost killed. And the father's going to tell you about finding her under somebody else's jacket. Through an extraordinary UVA doctor, plus a very healthy young lady, plus a huge dose of good luck, I mean, it's actually wild to look at the pictures. She looks like she's about to die, and by the end of it, she has a little scar on the back of her neck. It's great. It was wonderful in terms of what she ended up with. So we were trying to split the difference. Otherwise, every single accident would be the felony.
Mr. Chairman?
Senator McDougal.
I'm with you in purpose.
I understand.
Right. My question was about definitions.
Right.
So is it anywhere in 18.2 that we
No.
defined serious bodily injury? And
2
if
to
the-
10. 2 to 10. 2 to 10.
And if the answer is not, then should we not put that definition into this section? Because
I understand.
I'm with you if what the definition you read gives me comfort, but I'm concerned that some people are going to try to say, oh, I cut my finger on something in my center console, and that's seriously bodily injury.
I would, Mr. Chairman, I mean,
Tell
we
you
could
about it.
either cross-reference the other code section, which at least it keeps us from having yet another that then diverges with every amendment down the road, or case law, or we could literally cite this word for word, or you could come up with your own. All of those would be options. The cross-citing would be the simplest, as defined in.
I'm agnostic on style.
But if you like that definition, you would use, as defined in 16.1-278.4, which is the Child in Need of Services code section.
You okay?
Mr. Chairman,
Senator McDougal.
in case somebody, but I'm agnostic on style, but in case somebody goes to change the CHIN's definition, which is possible, we might want to just lay it out for purposes of this subsection, serious bodily injury is, and grab that language.
You want to make that motion?
So moved.
You object to that?
No, sir, no,
Right.
that's certainly what we're intending.
You have somebody tagging in that might not like it.
I'm sorry. Okay, I'm being told there is a.
18.2.369.
Mr. Chair, can we ask this to go by temporarily? Just, we will figure out what he wants and find if that's better than the one that's.
Delegate Gilbert thanks you.
Yeah. Okay. Mr. We'll come back with one or the other. and,
We'll take that by for a minute.
Okay.
All right. Delegate Gilbert. House Bill 2470.
Thank you, Mr. Chairman. Mr. Chairman, ladies and gentlemen, this bill is intended to address the worst of the worst in terms of human trafficking. It targets those who would traffic a child for prostitution. It provides a mandatory minimum sentence of 25 years in prison for anyone trafficking a child in prostitution under the age of 15.
Is it 15, under 15?
Under
It's
15.
Under 15.
Yes, sir.
Okay.
So I'm happy to address why we landed there, if you have any questions about that, but it would.
Anybody have any questions of the patron? Anybody here who wishes to speak in opposition to this bill? Bill is before us. If it's our intention to report it, it needs to go to the Finance Committee.
So moved.
It's been moved and seconded the bill be reported and re-referred to Finance.
Thank you, Mr. Chairman.
It's easy.
Well,
As 15-0.
Today, but I'll take easy today, any day. Thank you, sir.
All right. Next, we have Delegate Krizak.
Thank you, Mr. Chairman. This HB 2576 is exactly the same as Senator Vogel's SB 1669.
That bill reported unanimously. It's the Sex Trafficking Response Coordinator. If it is our intention to do the same, it needs to go to Committee on Finance. We can certainly save some time. Subcommittee Chair doesn't object to that. All right, motion to add the financial contingency clause to it and report. Right, properly second. Anybody in opposition to the bill here? All right, the roll is open.
That's 15-0.
All right, next, Delegate Watts.
Thank you, Mr. Chairman. The bill is HB, excuse me, I'll get my glasses on, is HB 2087.
And this bill, Delegate, I'm sorry to interrupt you, maybe I can help you. This is similar to a bill of mine that reported out of here unanimously. It's a Crime Commission recommendation that unanimously came out of the Crime Commission, right?
No, sir.
This is not?
Not.
Okay.
However,
Oh, this is, I see. I got the wrong bill. Okay.
however, I'm sorry.
All right, go ahead.
However, it is a bill that last year passed this committee unanimously, passed the floor unanimously, but did not make it out of the budget conference when we had to reconvene in special session. So the only change between what the bill is now and it deals with, for the first time, creates a felony offense for those who knowingly are frequenting prostitution activities when they know that it involves minors. We have had, as you have heard even this morning, a number of bills that deal with, and a number of efforts over the years, that deal with those who procure the gangs, the racketeering, the pimps, and this is one that says, if you know that a minor is involved, it elevates it to a Class 1 felony, so for the first time, it's going after the Johns. The small difference between, although significant in my mind, between last year's bill and this year's bill addresses the issue that when you're using a vehicle, it does not include anything other than for prostitution. Last year, it elevated any illegal sexual act, and that is much too nebulous. And so this just only deals with use of prostitution.
Okay. Anybody here in opposition to this bill? Commonwealth's attorneys are here. Sorry. In support of this bill. All right. This bill, if it reports, needs to go to the Committee on Finance.
Mr. Chair.
I'm sorry, Senator Peterson first.
A couple questions. First of all, we just had Delegate Gilbert not 10 minutes ago give a bill that seems like it's the same thing, but yours is slightly different.
No, mine deals with the Johns activity. His dealt with all of the procurement, all of those that engage in the business of prostitution. This deals with the Johns who knowingly are frequenting and those places where prostitution is taking place, where there are the use of minors.
Okay. Further question, Mr. Chair? I mean, yours references code sections 347, 348, and 349. 347 is keeping a bawdy place. 348 is using vehicles to promote prostitution or unlawful sexual intercourse. That's 349, I'm sorry. And then 348 is aiding prostitution or illicit sexual intercourse.
And it's the felony offenses that are elevated, and so it would only be the instance where it involves a minor.
Okay, all right, thanks.
All right. Any other questions? All right, the bill is before us. There's a motion to report and re-refer to Finance. Is there a second? It's been moved and seconded. Roll is open.
Ayes 14, no zero, abstentions 1.
Thank you.
Thank you very much.
All right, next we have Delegate Murphy. $20.42.
Good morning, Mr. Chairman.
Good morning.
This is a wonderful bill.
I happen to agree with you.
Well, it started out last year when we tried to make the second conviction for violent domestic abuse a felony. And because there were 11,700 convictions, the price would have been $15 million. And that killed the bill. But the issue still needs to be addressed. And so what we have done with 2042 is say that for your second conviction, it's a mandatory 60 days in jail.
Yeah.
And I really appreciate a lot of the help that we've gotten from certain wonderful and excellent and fabulous staff people.
Good job, Charles.
Yes.
Yeah, I wish you'd given me a little bit of help on mine. Mine only cost $8 million.
Well, this does not have a financial component on
see.
our level.
I think maybe there's somebody here who has some concerns about this.
Good morning, Mr. Chairman. Maria
Good morning.
Jankowski, the Virginia Indigent Defense Commission. Senators, I would first encourage you to give real pause whenever considering mandatory minimums. Mandatory minimums across the board disproportionately impact marginalized people, people in poorer communities, minority communities. So for that reason, I would ask you to pause whenever considering a mandatory minimum. Moreover, this could end up being very disproportionately enforced. This could be worked around easily by any defense attorney and prosecutor. And you say, well, why would you want to do that? Well, as a defense attorney, I don't know that I'd ever encourage my client to plead guilty when there's a 60-day mandatory minimum. So either the prosecutor and the defense attorney are going to come together and work around the mandatory minimum, or depending on who the lawyer is and how much work they've done and how much they've cared about this particular case, you're going to have unequal justice across the Commonwealth, and that's always problematic. I would remind you that most cases in the Commonwealth are done and are represented and defended by court-appointed attorneys who on a misdemeanor are paid $120. Lastly, I would say if we end up having more trials, that is, I would say, more difficult on the victims because they will have to testify, potentially go through trial twice if the defendant chooses to appeal because of the mandatory minimum. For those reasons, I would ask you to not report the bill. Thank you.
Mr. Chairman, I agree. Isn't it true that mandatory minimums really are counterproductive across the board as a general matter?
I don't know that I can give you hard data to answer that question. I wouldn't want to mislead anybody to think I have research or data, but that certainly has been my experience and the experience as reported by Families Against Mandatory Minimums.
Okay, I agree.
All right.
I would just like to remind the committee that there's a mandatory minimum of 2 months to 1 year on your second conviction for drunk driving. I think a woman or a person being beaten, maybe even on a daily basis, deserves better treatment than that.
I'm not sure that council on the committee, members of the committee agree with that statement.
Mr. Chair.
I mean, with your statement of the law concerning minimums.
I'm not a lawyer, that was what I was told.
Yeah.
Mr. Chair.
I think it's 10 days. Senator Peterson.
Yeah, I think, let me ask a question, Mr. Benjamin. First of all, my recollection is on prior testimony on this bill that the first offense is typically given to a diversion or deferred program. Is that typically what happens?
That's correct, Mr. Chairman, Senator Peterson.
Okay, let me ask a further question. Delegate, you have 20 years, which is a fairly substantial length of time. Why 20? Is there?
It was in existing
code
law,
already?
yeah, it's in the code. I thought it should only be 5, but they told me not to touch that.
Okay, because I would be much more amenable to this bill if it was a shorter time period. 20 is a fairly long time period, but.
Well, anybody else here who wishes to speak to the bill? Bill is before us. Senator Saslaw moves that the bill be reported. Is there a second? Second. It's been moved and seconded. Roll is open.
Thank you.
The bill reports. Thank you.
Ayes 9, noes 5.
All right, next, Delegate Simon.
morning, Mr. Chairman, members of the committee.
Good morning.
I've got House Bill 2678, and I believe that you all may have already passed an identical bill from Senator Adam Eben earlier in the session on this one.
We actually passed a similar bill. They approach the same issue in a different way. And I think what we will likely want to do is to conform your bill to Senator Eben's and let you all duke it out and figure out which approach is preferable. I know that our crack legal team has no preference, at least between the two. I think you all just tackle the issue in a different way. And so the bill is before us. Is there a motion to conform and report?
Move to conform to Senate Bill 1736 and report.
All right. Is that okay with you, Delegate?
Perfect for me.
All right. It's been moved and seconded. The bill be conformed and reported. All right.
Ayes 14, no zero.
Thank you, Mr. Chairman.
There we go. Delegate Delaney.
Good morning,
morning.
Mr. Chairman. Good morning, committee members.
Got 1817.
This bill makes it a Class 1 misdemeanor for any person to knowingly sell or to offer to sell travel services for the purpose of prostitution or unlawful sexual intercourse. So this essentially gets at the issue of sex tourism, which has unfortunately become an issue that, as we learn more about human trafficking, both abroad and here domestically, is an issue that needs to be dealt with. So selling travel for the purpose of engaging in commercial sex, which is also known as sex tourism, has become an increasing problem in the United States. Entities who engage in sex tourism currently face no penalties in Virginia, yet the practice of sex tourism acts as a feeder into sex trafficking. So we worked through this bill we worked with Restaurant and Lodging and Travel Association to try to ensure that the language that we've captured here has really captured the offender that we're trying to target, to make sure that we have the opportunity to reduce this exploitation.
All right. And I'm not aware of anybody who has fundamental opposition to the principle you're advancing.
Mr. Chair, can I ask counsel a question?
Yeah, I do want Steve to talk a little bit about some concerns that have been identified and maybe some ways we can fix it. But Senator Deeds?
I was just curious about language on line 144 and 145, an offense set forth in section E1 of 9.1902. What offenses does that cover?
Actually, isn't that a violent sex crime?
Mr. Chairman.
Charles?
Those are the offenses listed in the sex offender registry as sexually violent offenses. I'm pulling up what all is in 9.1902 now. And under subsection E, it's essentially rape, object sexual penetration, aggravated sexual battery. There is the carnal knowledge offense where there is a more than 5-year difference between the victim and the perpetrator. There's I'll say child pornography. There's numerous offenses in there, but they all tend to be the more violent sexual offenses.
Mr. Chairman,
Sarah Edwards.
What's the definition? The way I read this, it applies to travel agents only. Is there a definition of a travel agent?
Mr. Chairman, we did define that in this for the purposes of this section. Travel agent means any person who, for consideration, consults with or advises persons concerned concerning travel services in the course of his business.
Okay. All right.
Steve, you want to just talk a little bit about a couple of the issues that we identified?
Mr. Chairman, some of the concerns that we identified include the following. These days, many travel reservations are made online, and so the travel agent may not even be within the Commonwealth and hence outside the purview of the statute. And so we were concerned that the bill might not achieve everything that the patron wishes it to.
Well, that, number one,
And then-
I mean, there's no way we can address that.
No, there is not.
Okay.
Secondly, we noted that the bill punishes travel agents from knowingly promoting travel for the purposes of prostitution, but there is no requirement within the bill that the person actually engage in prostitution. It's just if the purpose of the trip is to engage in prostitution. And then the more intriguing question we raised was there may be circumstances where the locality or the jurisdiction to which the person is contemplating travel has legalized prostitution. So, for example, under the way the bill is currently written, if an agent promoted travel to Nevada for the purpose of going to a legal brothel, that agent would still face criminal liability, and we did not think that the patron intended that. An analogy, Mr. Chairman, would be if a travel agent promoted travel to a state where marijuana usage has been legalized. Under the bill, if it applied to marijuana consumption, then that agent would be guilty. And again, we didn't think the patron wanted to go that far.
So, Steve, if we wanted to address that third concern of yours concerning making, Sarah Sasslaw.
Yeah, but what hers says is involving minors.
No.
I'd be kind of surprised if the Bunny Ranch, or whatever the hell that place is called, had, I think it's called the Bunny Ranch, if they had minors.
Steve?
Mr. Chairman, it does not apply just to minors. It applies to any act of prostitution. And we identified a way to remedy this if the patron wished, Mr. Chairman.
Which I don't think does any harm to the patron's object.
Yeah, right. Yeah, that's
Exactly.
what
Mr. Chairman, what we suggested was amending the bill so that it makes it unlawful for a travel agent to promote travel services, as the bill is written, for the purposes of unlawful prostitution.
I move that amendment.
I'm not finished just yet. Or to commit any act of sexual abuse as defined in 18.2-67.10, or unlawful sexual intercourse with a minor.
I'd be agreeable to that, Mr. Chairman.
All right. Is there a motion to make that amendment?
I move it. I move the amendment.
The amendment has been moved and seconded. All in favor signify by saying aye. Aye. All opposed? That amendment is adopted. Anybody here in opposition to this bill? You aware of any opposition to this bill?
Not aware of any opposition, Mr.
All
Chairman.
right, the bill is before us. It's been moved and seconded that the bill be reported.
Ayes 14, no zero.
All right, that bill is reported. Thank you.
Thank you, Mr. Chairman, and thank you, committee members.
All right, next we have Delegate Mullen. Counselor.
Your Honor. Good morning, Mr. Chair.
House Bill 1674.
That's correct, Mr. Chair. So this is a code cleanup bill that was brought to my attention by a new multidisciplinary team that we have on the peninsula that deals specifically with elder abuse. And the Commonwealth's attorneys, investigators, nurses, social workers, they all come together to be able to investigate potential elder abuse. I think it's a fantastic organization. This specific bill is literally a code cleanup bill. In the top sections under A, we say that an incapacitated adult doesn't have the ability to be able to make their own legal decisions. And then under section D, we say that we need the permission of somebody who is incapacitated. So we're just fixing that.
do you really believe that it needs to be fixed?
We had a circuit court judge in York County who brought this to our attention in the middle of a investigation and decided to, what was said was, "I will do this once," was the phrase from the judge.
Well, a person who doesn't give informed consent, I mean, if they're incapacitated, they can't give informed consent anyway.
If you're in a coma, you can't give informed consent. I agree. The code, though, still requires you to. It's a code cleanup bill. Certainly not the biggest thing that you're going to be dealing with anytime in the next 5 minutes, let alone the next 2 hours.
So this says, right, so that if somebody signs an advanced medical directive, it's going to be given effect as long as he didn't sign it when he was incapacitated.
That's correct.
But it's void if he signed it when he was incapacitated anyway, isn't it?
That is normally what the practice of the law has been, certainly every time that I've handled it in court, but that's not what the code currently says under this code section.
But isn't that common law? I mean, isn't that, I mean, how can
Senator, I'm not sure that I've ever handled the common law when it came to incapacity. I certainly have done this when it comes to the code, but I'm not sure that I've handled the common law. It certainly would be common sense,
I mean,
if nothing else.
Any document has to be signed with intent and
correct.
Capacity
That's
in
right.
order to be effective.
Same with any contract.
Yeah, right. So how can any document be valid if it's signed without capacity?
I don't think it would be. I mean, that's certainly Contracts 101 for all of us. The only problem is that the code was written incorrectly when it was last drafted.
Steve? I mean, do you feel that this is necessary?
We raised that question.
I had a circuit court judge who raised this as well as multiple Commonwealth's attorneys. I understand the committee's feelings on these matters.
Are you aware of any additional courts or just that one court where this has been a problem?
I'm aware of only the one court as of right now.
Okay. Commonwealth's attorneys have a thought on this? Position on it? No?
I don't
Okay.
believe that they spoke one way or the other. You know, I would imagine that they would be neutral on it.
Okay.
But I don't want to speak for Mike Doucette or anybody else.
Somebody is behind you.
John Mahoney, sir. We support the bill without any further comment.
All right. I mean, it certainly does no harm.
Mr. Chairman,
Steve?
I hear the patron when he describes, although the committee does not historically act by anecdote, if there are members of the judiciary who do not feel that, who feel that this would be necessary, then I think it may be appropriate. It certainly clarifies the situation.
All right. All right, the bill is before us. Need a motion one way or the other? It's been moved and seconded that the bill be reported. Gosh, I've got half the committee's votes here. I can kill anybody's bill.
Ayes 12, no zero, abstentions 1.
Thank you, Mr. Chair.
All right, thank you. Delegate Bell, are you ready? Is Rob here?
Chairman, I I don't, I passed something to your staff, and I've got, oh,
We ready?
okay. You might recall that Senator McDougal, who actually is not in the room, had a question about a definition. There were two definitions we found. One of them is in 369, which includes serious bodily injury or disease. Aside from that, it would seem to be at least in the 18.2 section, but maybe Senator.
Mr. Chairman, Delegate Bell is correct that there is a definition within Title 18, but the definition is for serious bodily injury or disease, and does not then define serious bodily injury or disease, but simply says that it shall include certain conditions. And one of those conditions was a fracture, which may not be as serious as the intent of the bill contemplates. For those reasons, we prefer the definition in Title 16.
All right. Do you object to that? You
No,
okay?
sir, no, that was, I gave them both ideas, or
All right.
shared my ideas.
Is there a motion to that effect? It's been moved and seconded. All in favor of that amendment signify by saying aye. Aye. All opposed? All right, that amendment is adopted.
Mr. Chair, I do not want to slow you down. We
No,
do have a
I-
couple of, the parents came from Fluvanna, if you have time to let them testify for a minute.
Absolutely. We'd be delighted to hear from you.
Yeah, that's good.
And understand there's a happy ending to your story, which is even is wonderful.
Thank you. Mr. Chairman and members of the committee, my name is Amanda Petrolak. I'm from Palmyra, Virginia. On November 21st, 2017, I was involved in a head-on collision with a drunk driver with my 8-year-old daughter, Claire, in the vehicle. For as badly as I was injured, Claire's injuries were far more severe. She broke the C6 and C7 vertebrae in her neck. She suffered extensive damage to the ligaments that attached her head to her neck. And she was almost internally decapitated. The night of the accident, the neurosurgery team decided that they should operate. They wanted to fuse her neck at the C1 and C2 vertebrae to stabilize her neck, her head and neck joint. With this type of surgery, she would have never again had any up-down or side-to-side movement in her neck. This is standard protocol for injuries like hers. However, pediatric neurosurgeon Dr. Hassan Syed wanted to try and preserve quality of life for Claire. He felt strongly that because of several factors, including new medical studies that he was researching, her age, the fact that she was a very active child in an excellent physical condition, that he wanted to give her body a chance to heal. They originally were going to then have her wear a halo for a couple of months. They decided instead, thankfully, to use a modified CTO brace that is essentially the same as a halo but not as invasive, so no screws in her head. But just as physically restrictive. She wore the CTO for 24 hours a day, 7 days a week for 10.5 weeks, which is an eternity to an 8-year-old. I am happy to report that her neck did heal and she's made a full physical recovery. They did not have to perform the fusion surgery, and Dr. Syed has been presenting her case at medical conferences around the country to other pediatric neurosurgeons as a non-surgical option. Although Claire has made a full physical recovery, she has not overcome the emotional trauma of the accident. She's fallen behind in school. She suffers extreme emotional instability and tantrums. She had improved but relapsed near the anniversary of the accident. We hope that with continued trauma therapy and support that she will overcome this as well. Because Dr. Syed took a chance and because of this new medical philosophy with this type of injury in children, Claire does not have any permanent damage. As I understand it under the current law, because her injuries were serious but not permanent, the offender cannot be charged with a felony. Due to this medical advancement, he can only be charged with a misdemeanor. It seems baffling to me that someone who recklessly causes injuries as severe as Claire's can only be charged with a misdemeanor. It's not reasonable that because of these advances in medicine that he avoids a felony charge. From an emotional standpoint, no amount of prosecution will seem proper for what our daughter has been through, but legally we really feel there should have been more options. Someone driving under the influence who causes serious bodily injury should have more severe consequences. Because of this, we support the entire bill and specifically creating the Class 6 felony for DUI maiming for an offender that causes serious bodily injury.
I think you're going to get plenty of support on this committee. So,
thank you.
Thank you. Yes, sir.
Mr. Chairman, members of the committee, I would just like to add that seeing your 8-year-old daughter at the scene of an accident wrapped up in a stranger's jacket is a powerless feeling. However, seeing the person that did this receive such a menial charge left us feeling completely powerless. To put her injury into a layman's terms, I would use a term by the skin of your teeth. Her spine was attached to her skull literally by a menial amount of material remaining. It's hard for anyone to imagine that this type of injury would only receive a misdemeanor charge. Thank you for your time.
Thank you. And we just couldn't be happier to hear how
Thank you,
well
Mr. Chairman. Yeah, this
she's
does have a
recovered.
wonderful ending, but it was a very tough road.
Yeah.
It does.
All right, there's
Yes,
a
sir.
motion properly seconded to report and re-refer this bill to the Committee on Finance.
Mr. Chair, thank you.
All right, thank you, Delegate. Thanks for working with us.
Mr. Chair, you did have a bill of mine that this committee did, PBI 2666. I was expecting to see it on the docket today for its resolution. If you wish to resolve it today rather than put it off to another day to be resolved, that's fine, but this was the bill you had about new DCJS standards.
Kristen? Is
I'm
it
not
on
out.
the-
I'm- It's,
Sorry, he's
I'm sure I'll be
referring to
back
House
with you
Bill.
again. I just, if that was something you wanted to take care of, you
And,
certainly could.
I think that probably will meet the same fate as the other DCJS training standards, and unless you want to come in and make a pitch for it, we'd be happy to take care of it
We're in that
without requiring
We're in that
your
stage of the
attendance.
proceedings when each body has different ideas about certain things, and if that's what happened to your bill, I would anticipate it certainly happening to mine, so I'm not trying to.
It didn't happen to mine, but it happened to other members of the committee.
Okay.
So-
It is what it is. I would.
All right.
Thank you.
Thanks. Next, we have Delegate Campbell. 1954. And my understanding is we have an amendment to this bill that might address some of the concerns that were raised in committee last time around. So this amendment, Delegate Jeff,
Yes, Mr.
basically provides that if an agent breaches their fiduciary duties, that agent can be taxed with the costs
Cost and
or
fee.
the attorney's
Right.
fees and costs at the judge's discretion. Is that right?
That's correct.
Or is it mandatory?
Mr. Chairman, members of the committee, Jeff
Is
Palmer,
liable.
that the current statute is mandatory.
Okay, so this would say that if an agent steals from the principal and through an accounting under, would that be under an accounting pursuant to 1614?
Mr. Chair.
I guess it would. It's the same chapter.
Mr. Chair.
Senator Peterson.
Do we just imply that we're reasonable on line 14 for attorney's fees, or is that already in the
Well,
code?
I think the chairman had expressed earlier an interest after the substitute was drafted. I was going to raise that point that.
I would
to-
move that we
to
add
make
the
a
word
line amendment.
reasonable before attorney's fees and costs.
All right, so Senator Peterson, you want to offer this substitute
I offer the substitute with that amendment.
with the amendment? Got that, Kristen? Yes, sir. All right. It's been moved and seconded to adopt the substitute as amended. All in favor signify by saying aye. Aye. All opposed? That substitute is before us. Is there a motion to report? Anybody here in opposition? All right. It's been moved and seconded. The bill will be reported.
Mr. Chairman,
I'm sorry. Strike
I
that.
have a question. It says here on line 16, paid on behalf of the agent, the principal or the principal's successor in interest. I mean, it's the agent making the payment.
Mr. Chairman, members of the committee, the current statute speaks to the agent using the principal's funds to pay the agent's own attorney's fees. And then this would say that basically they're making the principal whole.
So this would,
It's confusing.
well, hang on one second.
Sure. And if I could, let me,
Let me ask you this. So, does this, so a child files for an accounting under 1614, finds, because they believe or know that the agent has been stealing from the principal. So the child incurs $50,000 of attorney's fees fighting for this accounting. Find that the agent is, stole from the parent. This requires the agent to reimburse the principal for attorney's fees, but does it require them to reimburse the child who has standing under 1614 to bring this action?
well, it is the principal or the principal's successors in interest, and that's exactly what happened in the Mangrum versus Chavis case that brought this issue to light, that it was the child brought the lawsuit, but couldn't recover under this statute.
Mr. Chair?
But these are people who are not necessarily successors to the principal. For example, A8, principal's caregiver, or another person that demonstrates sufficient interest in the principal's welfare. So how does that extraordinary caregiver who spends $2,000 of their own money, how do they get reimbursed?
Well, Mr. Chair, I think that was what was left out when we tried to make this more narrow between the last committee meeting and this committee meeting, and just really try to focus on the issues at light. And then in those cases, we would defer to the American rule.
So that person, can you all maybe step aside and, look, I think that anybody in A1 through 9 who goes to the expense to fight this, who uncovers a breach of fiduciary duty or theft by the agent, they ought to be made whole as well. And, if you all can, does that make sense to you all?
It does, and that's what we're trying to accomplish in the earlier version.
But what your first version did was said that if that person loses,
Correct.
they can get tagged with the principal's attorney's fees, which I think most of us had real concerns about and didn't want to happen. Because we want to make sure that people with good faith aren't penalized. If that person brings a bad faith action, they can be penalized under 271.1.
Understood.
Jeff, does this make sense to you?
It does.
So can you try and craft some language? I don't know whether Kristen can help you to make it available to anybody who brings an action under
Mr. Chair.
1614.
Mr. Chair.
Senator Peterson.
Yeah, maybe I can sort of create two baskets here. If the agent is stealing from the principal, let's say by incurring attorney's fees or doing something, taking from the principal's estate, that would be covered by lines 13 through 14 because you're restoring the estate.
Correct.
Then the question becomes, how do you reimburse the principal for their legal fees and costs in bringing the action to remediate the issue? That should be what's covered in line 15, 16. So you might want to strike out the words "the agent" in line 16.
Mr. Chairman, it may be the committee's wish to revert back to the original version, which was amending a different section of the code, but really speak to when the agent has been found in violation of the chapter.
Mr. Chair,
Senator Peterson.
I hate doing this. Can we take this by for the week and I order?
Let's take it by temporarily. I think, Jeff, you're right that maybe this language at 63 through 67 can be modified to make it clear that you're not going to charge attorney's fees against somebody who brings an action pursuant to 1614, 1 through 8.
Yes, sir.
Okay. Can you see if you can do that?
Yes, sir.
Sorry, Jeff. All right, Delegate Hugo.
Mr. Chairman of the committee, thank you very much. This is House Bill
2528.
Yes, sir. And I think a number of you are familiar with this. This is the felony homicide provision that deals with trying to remedy the Woodward court case, which dealt with proximity of distribution of drugs. And Mr. Chairman, I know we've dealt with this and may go to committee, and I know different thoughts. The only thing I might ask, if you would, be generous enough, there's a couple from Prince William County whose daughter went through this, and they've been sitting here for like 2 hours.
Tim,
if they could take 2 minutes.
I believe, and absolutely,
Yes,
we'd be
sir.
happy to hear from them.
Yes, sir.
We had the chaplain of our police force in Harrisonburg and the son of the commander of the local Rush Drug Task Force lost a child and grandchild to a heroin overdose, and the Woodard situation prevented the prosecution. This dealer who's responsible is being prosecuted in federal court. So I'm acutely aware, and I'll tell you, I know that there have been discussions among chairman of House Courts and I guess Delegate Gilbert and me and Senator McDougal.
Yes, sir.
And some of the Commonwealth's attorneys. And I think I hope that we have some ideas as to how we may be able to bridge the gap that has separated us for the past 3 or 4 years.
I appreciate the chairman's all their help on this. Thank you, sir.
My inclination would be, after we hear from your witnesses, would be to conform this to the version that came out of the Senate last year, with the understanding that there's some things that we absolutely are inclined to give on, and just to move this along. I don't think that we can close the gap here today, but I'm very hopeful that we can actually emerge with a bill
Mr. Chairman,
this
thank you.
year.
I look forward to working with you on this. Thank you
All
for
right.
listening to our witnesses.
Sure.
Thank you, sir. Good morning, ladies and gentlemen. My name is Matthew Lowry. I'm an assistant Commonwealth's attorney in Prince William County. I don't think it's a mystery to anybody on the committee that when we talk about drug dealers, we're talking about people who peddle poison for profit. And, you know, that's a cliche line from jury talk. But when the opiate epidemic, it's unquestionably true. And I will just tell you as a line prosecutor that we run into problems all the time, much like Senator Obenshain just mentioned, where there's a gap in the law where we cannot go after the superior drug dealers for the deaths that they're causing. This bill addresses that. The Association of Commonwealth's Attorneys supports the House bill as written. I want to introduce you to the Chazen family. The Chazen's daughter, Amanda, was an EMT in our community. She suffered an injury and ultimately was addicted to opiates and died from street-obtained fentanyl. But I'll let them speak, and they have a story that's important and poignant, but also quite typical.
Yeah, we'd be delighted to hear from them.
Good morning, and thank you for this platform. I don't know the background you guys have with drugs, but I know the public sees drugs as seedy motel rooms, trailers, row houses in low-income neighborhoods, not the suburbs. I grew up in Manassas City, a suburb of Washington, D.C., to a good family. My father was in the military. My mom works for Prince William Jail. I've been in law enforcement for 10 years. I have a master's in criminal justice, and I'm a law enforcement officer also for the United States Coast Guard Reserve. My sister wanted to help her community. She became an EMT. She got hurt on the job, got prescribed opiates, got hooked on opiates, couldn't get off of it. Started going to the hospital, the ER rooms once, twice a month to get whatever she could get prescribed to her. After that, it just got worse and worse. November 2017, she had an incident where she ended up in CPAT, a drug and psych ward at Prince William County Hospital. March 20th of 2018, I got a call from my dad that she had passed away from opiates. I went over to my family's house. We had to clean out my sister's apartment. It wasn't something anybody wants to do. I know this bill is not going to stop opiate use. It's not going to stop drug dealers. People are always going to want to make a quick buck. but I really hope you guys think about your sons, daughters, nieces, nephews, family members, you know, when you pass this bill, because this happens to anybody, families in the suburbs, family from high incomes, low income families. This can happen to anybody, and I really hope you guys think about your loved ones and other people's loved ones and hope this prevents something in the future. Maybe make a dealer think twice before he sells to somebody. Thank you.
Well, thank you for being here and for sharing. It's tragic, and this tragedy repeats itself all too often. We want to make sure that our public safety officials have the tools necessary to address it. So thank you for sharing. Yes, ma'am.
I am Mary Ellen Chazen, Amanda's mother. I forgive the two men involved in the drugs. It doesn't make it all right, but I can't live with hatred. The young man who lived across the hall is the one who supplied the fentanyl to Amanda. Amanda knew better. I don't know what was going on in her head that night, but she's dead. And the fella across the hall who gave her the drug is going to plead guilty next month, as well as the person who supplied the drug to him. I think if you are irresponsible, and I do know that Amanda is not completely innocent. She took the drug. But I think that there should be a stiffer penalty when a death occurs, and maybe it will make some people think that it wasn't worth it. That's all.
Well, thank you for being here. We're so sorry for Amanda's death, and just really pray for peace and comfort for you and your family. I just am grateful for your sharing. Yes, sir.
Thank you for this opportunity. Mr. Chairman, I appreciate your remarks and your support. My name is Martin Chazen. On March 20th, 2018, at approximately 4:35 a.m., the Manassas City Police Department knocked on my door. They said they needed to talk to me outside. I looked at them, and I knew I said, Amanda, our daughter, was dead. They said yes. Then came the hardest thing in the world that I ever had to do. And I was in the Army 22 years, and I did a lot of hard things, but this was tops. I had to tell my wife that our daughter was dead. She screamed no. She screamed the second time no. Police said Amanda was probably snorting heroin, which turned out to be fentanyl. Fentanyl, in case none of you know, started out as an elephant tranquilizer. Takes 1 or 2 grains, about the grain of a sugar, size of a grain of sugar, to kill somebody. The only thing I can compare this to is Zyklon B, which started out as a pesticide and would kill 6 million people in the Holocaust. The opioid crisis, and some call it an epidemic, however you want to call it, crosses all ethnic, racial, religious, age, and economic boundaries. I would tell everyone to look around you. One or some of you, just as you have said, has been affected or will be affected by this epidemic. How the pharmaceutical companies let this onto the streets, I don't know. And I heard on the radio about 2-3 months ago, they're coming out with something even more powerful than fentanyl. But it's really death for profit when it comes down to it. I don't know if we can hold the pharmaceutical companies responsible, but it's possible. But I will tell you, a chunk of the generation, the 18 to 28-year-olds, are being lost to this society. The way I understand the current law, if the dealer deals in one location and someone goes to another location, and like happened with my daughter, they went from across the hall, no one can be charged with murder. We need to change this. I ask you, how many families will be left with a missing member at the holidays and other times due to this crisis? How many more funerals need to happen? How many more mothers will have to scream? How many more people will have to bury their child, which is probably the hardest thing in the world to do? And I used to have to bury people in the Army, and I was told that, and just can't top that one either. The thing you want to do with this law is make people leave the business. There's an axiom in business, when the price of business gets too high, people get out of it. All right? As my son said, there's always going to be dealers, either making money or they have to because they're addicted. But the thing is when the price of doing it gets too high, many are going to pull out, and we will save people. We need to change this law. We need to get this done, and we need to save lives. Thank you.
Well, thank you and your family for being here and sharing. I know it's painful, but it's very helpful, and we really appreciate it.
Mr. Chairman, I appreciate you working with us. I look forward to working with you. Thank you, sir.
All right. Senator McDougall moves that we substitute the language that we used last year with the understanding we're working with you, and we have some ideas for how we can narrow the gap in conference. Senator Stewart seconds that motion. Any further discussion? And re-refers it to finance. The roll is open.
That's 15, no zero.
Thank you, Tim.
Thank you, Mr. Chairman.
All right, next, Delegate Toscano. Delegate Campbell? Okay, hang on. Kristen needs a minute. Delegate Toscano? Not you. You can come right now.
Yes. Good morning, Mr. Chairman, members
Good
of
morning.
the committee. I've got HB 1988, which, golly, by comparison to the last bill you heard, this is just not that significant. It's in the domestic relations field, and it has to do with how courts in Virginia have been determining how best to divide marital pensions in military cases. In December of 2016, the Congress passed a new Federal Authorization Act, which included an amended definition for how military retirement pay under the Uniformed Services Former Spouses Protection Act was to be handled. Mm-hmm. And it created some confusion for Virginia courts. And as you know, in domestic cases, we have to do what's called equitable distribution and divide pensions during the case. The new federal law created some confusion for Virginia courts, and what we're trying to do with this bill is make it clear that when you deal with a military retirement, you have to consider the federal law, which supersedes the state law in this regard. The Bar Association brought me this bill. I think it's supported by the Family Law Coalition. And I don't know who's here to testify for the bill. I know Jeff was involved, but he's been engaged with some other stuff. But if you have any questions, I'm happy to take them, or Jeff can answer them.
Anybody on the committee have any questions of the patron? Senator McDougall.
Mr. Chairman, I guess I have some concern about us putting a federal act into our state statute. So
I have lots of concerns about it too, but the problem.
So what's the negative for us?
But I think the courts need direction as to what they're going to do when this case gets to them.
Mr. Chairman.
Senator McDougall.
But why do we have to put it in our state statute to give them that direction? Y'all clearly know about it. Why can't they learn about it at a
members of the committee,
bench conference?
Sorry, Jeff Palmer on behalf of the Virginia Bar Association, and this did come from the Virginia Family Law Coalition. So Virginia's equitable distribution statute uses, when you're determining the share of a pension, the date of separation. The federal statute requires states to use the date of divorce, and that's what's created the confusion among state court judges who say, well, I don't care what you're saying about the federal statute. I've got to follow the letter of the state law. And so basically this is creating a signal to them that the General Assembly has reviewed it and recognized that there is this federal law out there that they need to pay attention to and follow, despite what the state statute says.
Senator McDougall.
Why wouldn't we say, except in cases of military retirement benefits should be at date of divorce? Why do we need to put the federal statute in? If that's the specific issue, why wouldn't we just say we do it for date of separation, except in
If somebody has a retirement, a military retirement benefit, then that's from date of divorce. And then we're not putting a federal statute in the code.
Mr. Chairman, when the Family Law Coalition looked at this issue, we just felt like that was the easiest way to cross-reference the statute rather than trying to incorporate that into our law.
And Mr. Chairman, when you do these divisions, and I don't know how many up here on this panel do them, oftentimes they're done by a separate court order acceptable for processing, which then goes to the feds. And if you don't have the instructions right on that order, it can create a lot of problems for the payee spouse. And this way that the bill is defined will make it a lot easier to get those monies to the payee spouse more quickly without more attorney's fees being incurred by having some debate between what a state court and feds.
Well, help me out, because this just says termination military retirement benefits shall be in accordance with, and then the federal statute is laid out.
Yeah. Yes, and
What
so.
what if we just said, any determination of military retirement benefits shall be from the date of divorce?
Mr. Chairman.
How is that different?
Senator. Well, all right. So the way the federal system operates, it's not just, see, in the state system, you do years of service and salary. In the military retirement system, it also interjects rank. So if you define this to say that the definition will be as of the date of divorce and it doesn't include rank, then you got another problem. So the reference here, and you correct me if I'm wrong, Jeff, but the reference here is to the federal statute, which would allow rank to be considered. Under the Virginia statute right now, it isn't, right? So that's why it's referenced like this, so that the court can take into account all of these things that the military retirement system needs to have done.
All right, any other questions? Anybody in the audience wish to speak to the bill? The bill is before us.
Move report.
It's been moved and seconded that the bill be reported.
Thank you. Thank you.
Whoops. Thank you.
Ayes 12, noes 3.
Ryan. I wanted to acknowledge some guests who are here. We have a delegation of Serbian elected officials who are being hosted in conjunction with JMU. And we welcome you and thank you for attending. You want to stand up? Thank you for being here. All right, next we have Delegate Campbell. I like this a whole lot more. Kristen, do you have a substitute? Or-
Yes, Mr. Chairman, it would be amendments to the original bill. In subsection E, the new language would be, in any judicial proceeding involving a claim for breach of fiduciary duty against an agent who is found to have violated the provisions of this chapter, the court, as justice and equity may require, may award costs and expenses, including reasonable attorney's fees, to any person who petitions the court for relief under subdivisions A1 through 8 to be paid by the agent found in violation. This provision applies in a judicial proceeding concerning a power of attorney commenced on or after July 1, 2019.
Right, and the only other suggestion that I have is, this statute is a statute that provides for an accounting. So should we say in a judicial proceeding for an accounting, or in a judicial proceeding under this section or chapter?
Chapter.
And provide that in the event of that there's a finding of a breach of fiduciary duty, the fees are awarded? Because, you know, and I actually have one of these pending right now, and it's an accounting action.
Sure.
So if the court were to find a breach of fiduciary duty, then it could award these fees. Can we make that change, Kristen, in concept? Okay. You okay with that, Jeff? Yes, sir. All right. Is there a motion to adopt the amendment reported by Kristen
So
and
moved.
modified in concept? All right. It's been moved and seconded. Any further discussion? Clerk will open the roll.
This for the amendment or this?
This is to report. Senator Stewart moves, Senator McDougal seconds. Motion to a report. As amended.
Ayes 15-0.
Long Road, thank you very much. Next, we have Delegate Foy.
Good morning, Mr. Chairman, members of the subcommittee.
Good morning.
I am here on House Bill 2119. House Bill 20.
Delegate Foy, this is, members of the committee, and I don't want to cut you off, I'll certainly let you have your say, but just this is the House companion to Senator Barker's Senate Bill 1279, which allows certain school attendance officers to sign motions for rule to show cause and for children in need of supervision. We have had concerns about increasing the number of pleadings that non-attorneys can sign. We, a couple of years ago, made an exception to that in conjunction with the Department of Child Support Enforcement because of the incredible number of child support orders out there which might have been declared invalid had we not made that exception. But there were serious concerns about expanding that because who's next? And as a consequence, that bill was passed by indefinitely on a 15-0 vote. So,
Mr. Chairman.
Senator Stewart.
And that is exactly correct, except what we did was we asked the Committee on District Courts to take a look at this and come up with a strategy for us. And I don't know if you're familiar with that committee, but it's folks from all parts of the judicial system, including the Chief Justice and legislators on that. And typically these types of issues, that committee would look at and determine whether it's a good idea or not, and if it is, how you enact such a thing as that. So I would anticipate we would do the same thing with this bill to have the Committee on District Courts look at it.
If I may?
You may.
Okay. There are slightly different, there's some changes that were made to my bill that's different from the Senate version that you saw earlier from Senator Barker. And so I hope that maybe it'll be more compelling with some of the changes. But if I may briefly, so it is absolutely correct. This bill comes from a compromise by GAL's Public Defenders Commonwealth Attorneys to decide how to fix the issue of notifying the court when children under a Chin's petition are ordered to go to school and they do not comply. And so this is actually supported by Virginia Association of Commonwealth Attorneys and the Prince William Commonwealth Attorney Paul Ebert. It passed the House unanimously, and a broader version of this bill did pass. This subcommittee in 2016. However, we have narrowed my bill a lot, hopefully to address some of the concerns that was presented here today. And so what this bill does is allow attendance officers to only file basically the attendance record along with the petition telling the court that this child was ordered to go to school, this child is not attending school, and that is it. The attendance officer cannot argue motions, they can't draft pleadings.
But they are filing a petition, right?
Yes, yes,
Okay.
and attaching the school record with the petition, and that is all. There's no other practice of law that's involved, no drafting
Chairman.
pleadings.
Senator McDougal.
On the juvenile side, we have a juvenile intake officer that deals with petitions. What is wrong with that current process? I mean, this is, in essence, it's going to be a show cause. A individual's going to have to write to counsel once they get to court. Why would we not want that same sort of magisterial process to be in place? To
Thank you,
protect
Mr.
the juvenile rights as much as you would an adult right.
Yes, thank you, Mr. Chairman and Senator McDougal, for that question. What happens is that there is an influx of duties for the intake officer. So what the current problem is, and we see this in Prince William County, is that the court will order a child to go to school. The child's not going to school. No one knows about it. The intake officer is already so consumed with all of the other duties that the intake officer has to do that by the time the intake officer finds out or is notified, or because they actually have the obligation to go reach out to the attendance officer and say, hey, has this child been going to court? Attendance officer says no. By that time, we're talking about weeks or months that this
Mr.
child has
Chairman.
been truant.
Senator McDougal.
With the process that it works with every other intake petition, typically it comes from law enforcement, sheriff, police, state police. Those individuals will go to the intake officer, fill out an affidavit, give it to the affidavit with a recommended petition to go forward. That intake officer then has to either say the petition should go forward or should not. They sit as a probable cause hearing before somebody's served with a criminal or quasi-criminal offense. What is wrong with this truancy officer going to the magistrate and giving them that docket of information? Why? I don't understand why that's a problem.
Absolutely.
Go ahead.
Okay, if I may.
Well, let me just say, I mean, this is the same bill, same concept. I know you've taken the form out of this, but I don't know that this committee has a different view from the view that it took on Senator Barker's bill. So, I mean, unless there's a sentiment to do something different than we did with Senator Barker's bill, I thought that sending this to the Committee on District Courts was a sound approach.
Mr. Chair?
Yes, Senator
And
Peterson.
let me just cut to the chase, because I was here a couple years ago when this concept was first introduced about having non-attorneys file petitions for rule to show cause, and I was vehemently in disagreement because I figured that so many other administrative agencies would be coming in behind it. And delegate, it's not a reflection on you. I just oppose to this concept. So, I understand exactly what you have to say, and I think you've done a good job of shaping it to be narrow. But for me, it's just I'm opposed to the concept.
Absolutely. Mr. Chairman, may I have
We're
Mary
just not
McGowan
gonna-
address?
And I'm happy to have her here,
Okay.
but we're not going to relitigate this bill
Yes.
unless there is a contrary sentiment on the committee. I mean, I certainly want to afford you every courtesy, but I mean, this is the same concept that we've addressed earlier this year.
Chairman Owen, if I could address Senator McDougal's concern, please. Mary
But that's
McGowan.
the same concern that was expressed earlier
Yes,
this year.
and I'm thinking
you
perhaps
testified
that's
earlier
something
this
that
year.
this committee, that the District Courts Committee could address. But that was our concern. That is why the Senate bill had it going through the juvenile intake officer. I'm not sure why on the House side they changed it back to the clerk, removing those layers of review if you did. But certainly we would be receptive if the District Courts Committee to entertaining that kind of an option.
Okay.
Thank you, sir.
Well, if we pass it by indefinitely, it would be my intention to write a letter to the Committee on District Courts and ask them to look at this.
Thank you, sir.
Okay, there's a motion to pass the bill by indefinitely, properly seconded. Roll is is open.
Thank you.
Thank you.
Ayes 11, noes 4.
Next, we have Delegate Collins. $1630, excuse me.
Yes, sir, 1630. This was actually brought to me after a substitute judges conference. Basically, what they were advised is that if you're a substitute judge, your appointment only lasts for a 24-hour period, and therefore any order signed after that 24-hour period is null and void, right? And so the issue would be if you are a substitute judge and hearing a juvenile court case, custody visitation case, and then after say that it concludes at 8 or 9 o'clock at night, and you're a substitute judge, you want to take things under advisement and think about it before you render an opinion, you would not be able to do that. So originally the bill asked for 7 days. The Supreme Court came and asked me to extend it out to 14. So that was on their motion. So that is the reason for the bill, and that's the purpose of the bill.
Senator McDougall.
Mr. Chairman, and maybe if I saw Eileen back there or somebody from the Supreme Court, they come up. So when you're appointed a substitute judge, the circuit court judge of, I guess it's not just a circuit court, but the circuit court judges get together, select substitute judges, appoint them for the area. Typically, the way the substitute judge ends up being there is a call from the clerk saying, please help me, I have a problem for today. So is that the official appointment? When the clerk calls them and says, can you show up today? Is there a form signed? Because Mr. Chairman, because my question is, they don't stop becoming a substitute judge after they set for the day. So I'm trying to understand how this process, because I've not heard of this issue before.
My name is Brandy Singleton. I'm with the Office of the Executive Secretary. So for substitute judges, and this stands in contrast, for example, to retired judges who are recalled, their appointment is time limited. I cannot, and I'll just be honest with you, in the weeds of that, whether there is an order entered, I believe there is, but I can't remember how the back infrastructure of that works. I apologize.
Mr. Chairman,
McDougall.
Wouldn't it just be if there, and I'm unaware of an order that's entered, but if there is, wouldn't it be easier to say an order entered to set this time and sign any orders that originated out of the hearings that were heard within the appointment time? Isn't that a much cleaner way than to have it go for 14 days, if that's in fact the case?
I think that is practically what the patient's trying to get at, and he has identified a problem. This comes up with some degree of regularity, whether through inadvertence or the need to give something further consideration than the day allows for.
Senator McDougall.
So does the Supreme Court grant the order? I mean, who is granting?
I think Delegate Lindsay, as a former substitute judge, can speak to the origin of the order that affords them that appointment.
Phone a friend.
Mr. Chairman, members of the committee, I'll just tell you succinctly, what happens is there's an order of appointment from the circuit court that gives a 6-year term for substitute judges. We get called, or I say we, formally we get called on a date that the General District Court had some need. The assignment only lasts for that 24-hour period. So you could marry someone that day, you could proceed and rule on cases that day, but you could not sign orders there afterwards. And a lot of times what happens is those orders that don't get entered on that day are left for the judge. Some judges are very comfortable signing those orders. Some judges are very uncomfortable signing those orders.
Mr. Chairman?
Senator McDougall.
So is that the 24 hours statutorily?
It's a most recent opinion.
By?
So this, at the substitute judges conference over this past summer, that was the ethics opinion that was rendered to the substitute judges who are not retired judges. This is for the regular sub judges. They said that your appointment expires at the end of the 24-hour period.
Who made that, issued that opinion?
I'm not sure if that was a bar opinion or if that was a judicial opinion.
Mr. Chairman?
Sir McDougal.
It would seem to me that the Supreme Court could fix this very quickly by saying how long those appointments last and whether they can sign orders as opposed to it being a statutory fix. Because thank you for bringing this because I've never heard of that. Because I know a lot of sub-judges that get called at like noon saying, can you hear a 1 o'clock case or 2 o'clock case?
And Mr. Chairman and Senator, I would respond that I think that for those of us that practice law probably would never raise that issue. To say that a substitute judge who heard a case who enters an order 3 days later, that order would not be valid. But this is now saying no, that there's an argument to me that order is not valid. And if the Supreme Court would like to fix that, I am happy to do that. But there are 3 branches of government here, and since they have not taken action on this, and they're the ones that are teaching their sub-judges, I felt that it was my prerogative to bring potential legislation.
Senator Stewart.
Mr. Chairman, I kind of like Senator McDougal. I've never heard of this issue or this problem, and as I read the statute, beginning at the end of line 25, while serving as a judge of the court, the judge or the substitute judge may perform all acts with respect to the proceedings, judgments and acts of any other judge in connection with any actual proceeding then pending, or therefore dispose, et cetera, et cetera. So I think it's pretty clear under the statute, but what concerns me is this, Delegate Collins. The district courts are the province of the Supreme Court, and I do believe in the separation of powers doctrine, and I think this is an issue that the Supreme Court should be looking at instead of this committee.
Mr. Chair.
Senator Deeds.
Isn't the question of one of definition, this term in the statute at the end of line 26, while serving as judge of the court, is that last for the 6 years or the 24 hours?
And that's where the opinion rises from.
The reality in the district courts in Bath, Highland, and Allegheny, we've had nothing but substitute judges for the last 3 years.
So I wonder whether maybe this is another issue that is ripe for consideration by the Committee on District Courts.
It may well be, Mr. Chairman. I would just point you to some existing statutory language. The sentence that begins with "while serving as a judge" has a final clause that you can see on line 28 that says, "except as otherwise provided in this chapter." If you would lend me Title 16.1, I have a feeling that limitation might be contained in a code section that's on either side of this statute before you.
Okay. You want to take that by for
We can.
a minute, and you're
We'll get you a better
certainly-
answer.
I think 16.1 is coming. All right, Chris, what's next?
Then I have the sex offenders and taxi cab drivers bill.
2300. All right.
Thank you, Mr. Chairman. Ladies and gentlemen, this bill came to me due to we had a registered violent sex offender driving a taxi cab in my locality, in my jurisdiction. He was driving as an employee of his wife who had gotten the taxi cab license. Upon further investigation, everything we all might remember when we did the Uber and Lyft, we put language in there to say that you had to do a background check and to prevent someone from being on the sex registry from driving a Lyft or an Uber. We have remained silent. We have allowed localities to govern the taxi cab industry. I will tell you that there are several localities that say a sex offender cannot operate a taxi cab within that county or within that city. But it is not. But it's up to localities to do that. And when I brought this to other localities' attention, they didn't even realize this was something that they could look at or should deal with. And so this language is identical or mirrors very closely the language we used for the Uber and Lyft language we did in 2015. We just copied it and pasted it so that we would not, no one is getting any more of an advantage or more of a disadvantage with this bill for depending on which company you're dealing with.
All right. Anybody have any questions of the patron? Anybody wish to speak to the bill?
Mr. Chairman, committee members, good morning. I'm Mary DeVoy. So this bill passed out of the House subcommittee with very little discussion, and I do hope today we can consider the specifics of it. Those listed on the Virginia State Police Sex Offender Registry are the most managed, monitored, banned, and discriminated group of people with a prior conviction in the entire state. No other group of citizens has more legal limitations on employment than registrants. Additionally, many corporate and small business owners will not employ them. For these people, employment is increasingly out of reach, while destitution becomes a greater reality. I am 100% supportive of public safety bills that are based on facts and data. This bill is not based on either. There has not been a single case of a Virginia registrant driving a passenger vehicle that has assaulted a driver. Yet, since Uber came to Virginia, there have been multiple people who are hired Uber employees who have assaulted passengers. They were not on the registry. The patron has failed to mention that the recidivism rate for VSP registrants is the lowest in the state. The last time the Department of Corrections measured it, it was 2.14% for a new sex crime. Of that small percentage, 9 out of 10 times the assault is against an acquaintance, not a stranger. Wouldn't it make more sense to just ban all men from driving passenger vehicles or even being teachers, because they commit approximately 95% of sex crimes in the Commonwealth? Transportation providers in Virginia can and should, in my opinion, install video cameras in all their vehicles. That would be smart public policy. This bill will take away the current livelihood of any registrant who's driving a taxi, a limo, a bus, or a shuttle today.
Mary.
This bill gives them no due process or appeal. It doesn't matter how long ago their conviction was or how spotless their driving record has been.
Mr. Chair.
Yeah, Senator
And
Peterson.
I hate to cut, this is
Yes.
very, I'm with you, okay?
Thank you.
Can I make a statement?
Sure.
I was a lawyer representing a taxi cab company for 20 years.
Yep.
And these issues are regulated at the local level. Taxi cab companies are a creature of a local ordinance.
Sure.
And each locality that I know has a criminal background check, and they may or may not weed out these folks, or if they do, then the bottom line is we've always delegated this to the
To
local level.
localities, yeah.
Taxi cab drivers, for one thing, this is often an occupation of last resort for a lot of people, okay? And so, without having some firm data that there's actual assaults occurring, I would be very loath to pass this bill, because again, this is being regulated at the local level, and I'm not aware that there's a problem. I understand the Uber-Lyft comparison, but Uber-Lyft are not branded vehicles in the same way that taxi cabs are, with a dispatch service and a defined service area. So just from my perspective.
When she's finished, I can answer your questions.
Thank you, that's my comments.
Do I continue? So from a legal standpoint, I also believe this bill would mean that any construction worker or landscaper who is driving their crew to a job site, whether in their own vehicle or their company vehicle, because they are on the clock and being paid with passengers, would become a crime. How does being a registrant driver create a more dangerous situation than being a passenger? It doesn't. So will there be a future bill saying that registrants can no longer ride on city buses and cabs? This bill is unnecessary, and I do hope you will vote against it.
Thank you.
Thank you.
All right, so one point that Mary brought up that maybe one that I'm sensitive to is, I mean, this is broader than taxi cabs. Her point about driving, the work van. And is there a way to address that? I don't know what, other than taxi cabs, what the term of art is for taxi cabs.
And the language that we used in here, we originally had taxi cabs, and then we thought that was a little bit too narrow. We didn't really have a good definition for it.
Well, and what I thought this was basically conforming the law. I carried several years ago I think I did the bus bill, primarily because of the kids going on school field trips and having bus drivers in a position that we didn't want them in. The Uber and Lyft, the TNC legislation has a prohibition. I thought this was conforming taxi cabs to that. and that makes sense, but.
And I'm happy to put taxi cab back in there. The taxi cab industry had some concerns that we were calling it that. But that is the purpose of this. I don't want to prevent the guy who's driving his kids to school who gives them chicken nuggets as to be compensation for driving a cab. That's not the target here, obviously. So I'm happy to go back to the original language that we actually use taxi cab in the bill. And I forgot my laptop, so I don't have
Kristen, do you have a suggestion as to how to more narrowly tailor this? Or Steve?
Mr. Chairman, if you're referring to the breadth of the bill sweeping into its embrace Greyhound buses?
No, more like construction vans carrying employees to the job site.
Yeah, that's the only. Mr. Chairman, the only, we were discussing the same sort of thing, and the only, we could not identify a precise word that makes the distinction. The best we could do was think of capping the number of individuals that the vehicle is designed to transport. That, however, would not go to your concern about a construction van. We were focusing on the fact that the bill as written would include somebody who drives a Greyhound bus.
Well, that's already covered in a different statute. How about taxi cabs?
Mm-hmm. When
may
the
have
original
an
draft had taxi cabs in it.
We may have an opportunity to address that further later on.
That's fine. I'd be happy to try to.
Is there a motion? It's to change it to taxi cabs. TNC's already.
TNC's already covered in a different code section.
This would be conforming the law for taxi cabs to what already exists for buses or TNCs. Is there a motion to amend to limit it to taxis? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? All right, the bill is before us.
Mr. Chairman, one other concern that we try to point out each time, each time an additional restriction is placed on people who are already required to register, it makes the entire registry more vulnerable to eventual challenge. This has happened elsewhere, and one of the reasons is because this operates as what we know as an ex post facto punishment. You're punishing somebody for something that they have already done. And so we always want to make sure everybody understands that it could have that consequence. One possible fix to alleviate that somewhat would be to provide that this applies, and this may not be what the patron wishes, but the suggestion would be to have it apply to anyone who because of an offense committed after July 1, 2019 is required to register. Again, that might be inconsistent with the patron's intent, but I wanted to offer that.
Or could it be limited to the sexually violent?
Mm-hmm.
Certainly, Mr. Chairman.
Rather than the full list? Would you object to that?
I have no objection to that. I think that to Senator Peterson's comment, he's absolutely correct in that we have let these localities, but as I said, my locality did not have any regulation for the cab industry. And they have taken no interest in resolving this particular issue. So I have no issue with that. If we believe that will prevent a constitutional challenge to what we already have in place.
Mr. Chairman, I have a question.
Senator Edwards.
With regard to Uber and Lyft, I'm not clear. We have a state law that limits the people cannot be sex offenders. Is that right? Okay.
Correct. In 2000, sorry, excuse me, Mr. Chairman, Senator, Yes, when the TNCs were created, that was one of they had to do a background check.
All right. All right, anybody wish to move to limit this to? Okay.
Yeah, it's listed in 19.2.
We do, Mr. Chairman.
All right. Motion, is there a second?
Second.
Motion properly seconded. All in favor of that amendment signify by saying aye. Aye. All opposed? That amendment is made. Bill is before us. I'm sorry, Steve? It did not. All right, motion, is there a second? It's been moved and seconded. The bill be reported.
And I'll check
All
on
right.
my other bill.
All right.
15-0.
Next, we have Delegate Yancey. Delegate Yancey, you've got House Bill 2056, which is companion to the bill that Senator Chase carried, which reported out of here unanimously and out of the Senate unanimously. I think that unless you have a strong objection, our inclination is to conform your bill to Senator Chase's bill, and we can address any differences which are minor later.
That'd be fine, Mr. Chairman. Thank you.
All right, is there a motion to conform and report? It's been moved. This doesn't need to go to finance, does it? Moved and seconded to conform and report. Roll is open.
One more bill, Mr. Chairman.
That's 15-0.
All right, next bill, 2651. Delegate, my recollection is that this bill represents a subset of a bill this committee has already considered and reported. My bill, 1603, which actually made it to finance where it languished. This is a Crime Commission proposal passed unanimously out of the Crime Commission. I think it's important. I think that your bill may actually stand a better chance of getting out of finance than mine did for reasons that I can't explain right now. But I think your bill is in good shape. Charles?
Mr. Chairman, there is one amendment to the bill. On line 19, the word solely shall be stricken.
All right, sir. That amendment's been moved and seconded. All in favor of adopting that amendment, signify by saying aye. Aye. All opposed? Anybody wish to address the bill? Bill is before us. Does it need to go as it is? All right. Motion properly seconded is report and re-refer to finance. All right, Delegate Yancey.
Thank you, Mr. Chairman. Thank you, members.
Next, we have Delegate Les Adams. See here? Quick, Delegate. Huh? Oh, Collins, you ready?
I have an answer.
What is that?
I don't know.
Okay.
I walk up and everything starts beeping. I don't know.
What you got?
So to answer everyone's question, this was this was an ethics opinion by the from the General District Court, but it regarded to whether or not it's an older opinion saying that a substitute judge could not perform a marriage unless they were already anointed for that particular day. It has now been extrapolated and put onto and said that applies. This is the opinion. No one has. I don't think anybody's brought this to the Supreme Court yet. But they've raised the opinion to say, well, that opinion applies to your appointment for a 24-hour period. So we don't, it's the code is silent on the issue. This was brought to me by a substitute judge who went to the conference where they got this ethics opinion. So I want to make sure that, and I'm happy to see, if I take no harm if we think that this needs to be evaluated by the Joint Commission and have the Supreme
Can't
Court.
fathom who that sub-judge might be.
I'm going to, the person who shall remain nameless, Senator. I don't, just,
All right. Perhaps this is an issue that the Committee on District Courts could look at, and I'm sure that they will come back to us if they feel that there's a legislative fix that's required.
And I think probably just clarification, and if we need to do it next year, we will. But
Senator Stewart?
Mr. Chairman, I'd move we pass the bill by indefinitely with a letter to the Committee on District Courts to explore this.
All right. Motion properly seconded to pass the bill by indefinitely with a letter.
Ayes 14, noes 1.
Thank you, sir.
All right, thank you. Next, Delegate Adams, the Adams docket here today.
Sir.
I'm sorry for everybody else. I shouldn't be apologizing.
Four
You
quick
should.
bills, you're right, for you.
All right. We've got 2409.
Yes, sir, Mr. Chairman. Members of the committee, House Bill 2409 is the recommendation of the Virginia Bar Association to, and this was in response to a Virginia Supreme Court case that identified certain inconsistencies in the mechanics
This is
lane.
largely changing the form.
Yes, no substantive changes in the law.
You aware of any opposition?
I am not.
Anybody here in the audience wish to speak in opposition to this fine bill? Bill is before us. All right, it's been moved and seconded that House Bill 2409 be reported. All right.
Ayes 15, noes 0.
That bill reports. 2413.
Yes, sir, Mr. Chairman, members of the committee. This bill is the recommendation of the criminal conference from the VTLA. It does make substantive changes to the multi-jurisdiction grand jury statutes. In particular, it requires secrecy from those who are permitted to make notes, and there's a notification imposed on the Commonwealth attorney to persons who are indicted when evidence against them was obtained by this method.
All right. And Commonwealth's attorneys like this or not?
Well, they are in support. Good morning, everyone. Shannon Taylor, Commonwealth Attorney for Henrico County. Good morning, Mr. Chairman. Good morning, members of the Senate Subcommittee. VACA is in support. I am the co-chair for VCJC this year, and so I was here in support for Delegate Adams, who, of course, is also a member of our conference.
All right. Don't go anywhere because
Yes, sir.
I think Steve has an issue that he thinks we can address in this
Yes, sir.
bill.
That's right, Mr. Chairman, and this is, does no harm to the bill, and I spoke with Ms. Taylor about this ahead of time. You'll see on lines 31 and 32 that the attorney receiving these materials is permitted to make copies and use it as he deems necessary in a criminal investigation or proceeding. In order to maintain consistency, we should make the following two amendments. On line 45, after the word jury, insert except for disclosure as he deems necessary for use in a criminal investigation or proceeding. And then on line 48, after the word materials, insert, and in both instances, we have a comma at both ends, except as he deems necessary for use in a criminal investigation or proceeding.
And Mr. Chairman, yes, the only the comment I would make is when we talk about what is the use and the furtherance of a criminal investigation, understanding that that material may be subject to other orders with respect to what was happening with the discovery, any other protective orders of that nature. So that can be resolved within the presentation of how this case is proceeding in circuit court. I think Mr. Benjamin and I had acknowledged that there would be other methods out there to continue to protect the secrecy while counsel can still use the material in furtherance of its investigation to prepare for trial.
All right.
I move the amendments.
Is there a second? It's been moved and the amendments have been moved and seconded. All in favor signify by saying aye. Aye. All opposed? 2-0. Those amendments are adopted. Anybody here in opposition to this bill? Bill is before us. It's been moved and seconded that the bill as amended be reported. Roll is open.
Ayes 15, no zero.
The bill is reported. Next, we have House Bill 2414. This is identical to a bill that reported unanimously, Senator Stewart's bill. I don't believe that there are any differences or changes that are necessary. All right, it's been moved and seconded that the bill be reported.
Ayes 15, no zero.
And 2452.
Sir, Mr. Chairman, members of the committee, this bill is a recommendation of the Virginia Crime Commission following on the pretrial study that was recently conducted. And what it does is it amends the code sections affecting failure to appear in the Commonwealth only in so much as it directs a subsection so that we will know when persons are tried for contempt of court, specifically for failure to appear. It does not change the procedure in any way or the substance of the law, but only this will allow, because one of the challenges in the study was that they were unable to determine just by looking at contempt convictions how many of those were in fact because of failure to appear.
Okay. Anybody have any questions? I know Colin from the Crime Commission's here in case anybody has questions about how this fits in with their work. All right, the bill is before us. Yes, Senator Sturdivant.
Are there any, I don't do this type of law, are there any due process concerns about punishing something summarily versus a hearing?
Les?
I do not believe there is, but the existing, there's existing case law that essentially condones the current procedure. So this doesn't change summary contempt at all. And
all right. Any other questions? Bill is before us. It's been moved and seconded. The bill be reported. Roll is open. They were four quick
Ayes
bills.
15, no zero.
Thank you, Mr. Chairman.
Thank you. Next, Delegate Herring. Delegate Lindsay.
Good morning, Mr. Chairman, members of the committee. I'm here on HB 1675. HB 1675 attempts to amend the code with just one single line in subpart B of 8.01-15.2. It simply says that any attorney fees assessed pursuant to this subsection shall not exceed $125 unless the court otherwise deems a higher amount appropriate. The whole point to this, and the issue I'm trying to fix was that a couple of years ago, we changed the structure of this law to basically say that there couldn't be recommendations from the plaintiff's counsel as to the guardian ad litems, and it would be set by a list determined by the court. What happened, at least in my neck of the woods, and I'm from Hampton Roads, and we have a lot of these cases there with the Navy, military, and the like, Navy, Army, Coast Guard, and the like, is that when there's a judgment that is successfully rendered, against a service member, what happens is that the service member has to pay the cost of the guardian ad litem fees. And talking to the clerk's offices, what we determined is that with that change in the law from a small cadre of people who did it, the fees have shot up, to a great measure. The whole idea of this is to be directive that the fees, because these fees wind up having to be paid by the service members themselves. So the whole idea of this is to pump the brakes, so to speak, to put some direction in place so that it's understood that there's an expected amount that's not to be exceeded, and if circumstances bear it out, then the court can always exceed that amount.
And typically, these are perfunctory duties performed by the guardian in these cases, aren't they?
The guardian ad litem has to contact the military service member to make sure that they understand what their rights are under the act and make a report to
You
the
aware
court.
of any opposition to this bill?
I am not.
All right. Anybody in the audience wish to speak to this? The bill is before us. It's been moved and seconded. The bill be reported.
Thank you, Mr. Chairman.
Thank you.
Thank you, members of the committee.
Delegate Herring.
Ayes 15, no zero.
Good morning, Mr. Chair, members of
Good
the
morning.
committee. I am here on HB 2597. It was a recommendation of the State Crime Commission having to do with sex trafficking. I believe that there is a Senate version that went through another committee, 1661.
And my understanding is that you want to have your bill conform to Senator Peake's bill, 1661,
Yes.
and reported?
Yes, sir.
This doesn't need to go to finance, does it? It does? All right. Is there a motion to conform, report, and re-refer? It's been moved and seconded. Roll is open.
Thank you. I appreciate
Ayes
it.
15, no zero.
Next, Delegate Pillion. You. Delegate, this, my understanding is that there have been extensive discussions between you, Senator Carrico, the state police, the chairs and certain members of both courts committees, that the agreement that has been reached, of course, subject to both courts committees, is that you and Senator Carrico were attempting to address the same issue in slightly different ways that do not conflict with one another. My understanding is that Senator Carrico's bill is going to report in its current form as it left the Senate out of the House Courts Committee, and your bill should report out of this committee and be addressed without any changes. Unless anybody objects to that, that would be the chair's recommendation.
You are correct,
All
Mr.
right.
Chairman.
Any questions? Anybody in opposition here? Senator Stewart moves to report the bill. It's been moved and seconded. The roll is open.
Ayes 12, noes 3.
Thank you, Mr. Chairman.
All right, thank you. Next, Delegate Brewer. I'm sorry. Okay.
My apologies, Mr. Chairman, for not bringing lunch to you all.
All now. 2552.
Yes. The bill I have before you, House Bill 2552, had some vast changes from the House. So the goal of this bill actually is to just come in line with where technology is going. The Commonwealth Attorneys Association, actually I have someone here also to testify in the bill. But the goal is just to provide, obviously, some hard set rules when it comes to the usage of unmanned drones, when it comes to search warrants. So what they recommended the House and what's been brought over is bringing this in line with the GPS tracking statute. So it matches that pretty clearly.
All right, any member of the committee have any questions? All right, let's hear from those who wish to speak in favor of the bill.
Good morning, Mr. Chairman. Members, my name is Derek Colvin. I'm a senior assistant with the Commonwealth Attorney's Office for the City of Suffolk. As this committee is aware, the General Assembly created essentially a carve-in for search warrant requirements for the use of drones, meaning an officer or law enforcement agency has to get a search warrant to utilize a drone when they may or may not have had to under existing law. The proposed bill would define essentially the manner of service or notice to the person being surveilled. As the committee is aware, Virginia Code 19.2-60.1 for drones did not create some unique form of search warrant. It merely stated that a search warrant is required when it is to be utilized by drones. This means that the manner of execution, the manner of service and notice, the filing of the return, everything of that sort, all the general requirements still apply. A particular concern is, of course, in 19.2-56, where any search warrant, the affidavit has to be attached and it has to be served therewith. Therewith presumably meaning at the time of execution. When we're talking about the use of a drone, that does not work because a law enforcement agency cannot surveil a target while simultaneously giving them notice. It just would not be an efficient means of law enforcement resources. So we're asking the committee to pass this bill.
All right, thank you very much. Next.
Mr. Chair, members of the committee, Michelle Satterlin on behalf of the Unmanned Systems Association of Virginia. We represent the industry sector with unmanned systems. We support this bill. It promotes greater efficiencies and the greater use of unmanned systems within the Commonwealth.
Michelle, I hate to ask you this, but why would the industry group be taking a position one way or the other with respect to, I guess, the privacy issues?
We support the bill because it puts in place some parameters that we think will promote the use of drones, and that's the perspective we're taking.
So law enforcement is going to use them more. Okay, thanks.
Yep.
All right. In support?
In support.
Okay.
Commonwealth Attorneys Association supports the bill. Thank you.
Thank you. Opposition?
Yes. Good morning, Mr. Chairman, members of the committee. My name is Charlie Schmidt with the ACLU. I've talked to the patron. We certainly support the concept and the idea that they were trying to address in the original bill. But the way it got rewritten in House courts, we're worried that it flips the presumption for what law enforcement must do in order to basically delay the notification of delaying the notification that a search warrant is being done. The original language of the bill basically said that if there's good cause, which we feel is appropriate, if there's good cause such as like victims in trouble or someone's going to burn a field of drugs or something's going to happen where they feel that if they deploy the drone and then give notice of the warrant that there'll be some sort of problem. So if the original bill, the way it was worded was to say the police would go and ask for a delay, which we feel that is appropriate. The way it's written now, the way I read it, is the new language in paragraph E. It just says within 10 days after the use of the unmanned system has ended, a copy is executed. So that basically puts it so that any police officer by default can just run the drone up, not give any sort of notice to the search to the homeowner, and would like that rather be flipped.
So Delegate, I mean, were you happy with your original language?
Actually, I was accepted the friendly amendment at House courts, and I was fine with that. I mean, furthermore, I think I understand what he's attempting to say, but we're not trying to take all the criteria for search warrants. We're not changing that. We're merely trying to address a new technology in a gray area that Commonwealth attorneys are going to come in contact with each and every time.
Steve,
so the burden is still there to prove.
I'm sorry, Sarah
Yeah,
Peterson.
let me make a point, and I thought it was a long time ago, maybe it was like 5 or 6 years ago. We passed a pretty strong policy statement about 5 or 6 years ago saying we weren't going to use drones to execute searches. And that's what this code section was. And then we put in a few, Amber Alerts and a few other exceptions. Now I feel like we've got the industry coming in saying this is a new technology that we ought to utilize, and Commonwealth's attorneys love it. And there's this thing called the Fourth Amendment that says you got to actually have a search warrant before you can go and look at people's property. And I feel like that's kind of getting lost in the wayside here. So I understand this looks on its face like a process bill, but I'm starting to think that it's put the drone up, see what we find, then come back later with a search warrant kind of bill. And that is not going to be a good thing.
The inception of the bill was really to address some of the concerns, obviously coming out of a very large gray area. So we know law enforcement agencies are starting to use this a bit more.
Okay.
And so it was to address that gray area.
Ma'am,
Sarah Peterson.
There's no gray area. If you don't have a search warrant, you can't put a drone over somebody's house. That's not a gray area. I'm afraid we're creating a gray area.
All right. Steve?
Mr. Chairman, some of us identified the same concerns that the ACLU has spoken to. It would seem more appropriate to put the initial burden upon the law enforcement agency to seek, for good cause shown from the court, permission to withhold serving this.
Which was the original form of the bill, is that right?
Correct.
If I may say. Sorry.
Yeah, step up.
Sorry, and I did not clarify, in the original language of the bill, the problem the House courts had with just taking that language and putting it back in is that language comes from federal FISA courts, and they were worried about how that would be interpreted, bringing in language into our procedures versus taking something that was from our procedures, which was the GPS statute. I think, if I may make a suggestion, just striking the first phrase of within 10 days after the use of the unmanned system has ended. And so it would begin with a copy of the executed search warrant shall be served through this manner, but upon request for good cause shown, the circuit court may grant one or more extensions for such service for a period not to exceed 30 days. So then you get into, they have to go and ask for the delay through good cause shown before, instead of just this automatic, well, I can hold it for 10 days.
Doesn't that create logistical issues?
No, I think that works, Mr. Chairman.
Okay. You okay with that?
Let me defer to the Commonwealth Attorneys Association to see if they would be friendly to that.
I'm sorry. I'm trying to conceptualize exactly how that would be worded and what that would mean. To be honest, from the Commonwealth's perspective, or at least this attorney's perspective, I doubt that the original idea for the drone language was that the search warrant itself would be served on the target of the investigation, contemporaneous with the investigation. So this has nothing to do with diminishing search warrant requirements or probable cause or anything like that. Keep in mind, law enforcement officers do not need a search warrant to fly a helicopter over someone's home or to use binoculars. Essentially, that is what a drone is. It's just a very cheap version of a helicopter.
But, Mr. Chair.
Senator Deeds.
But, so you admit that this would add a drone as an investigative tool to allow you to establish probable cause for which you could get a search warrant?
Absolutely not. This is in no way affects the requirement of a search warrant itself. All this does is, we get the search warrant in hand. The magistrate's required to affix an affidavit, and that is required to be served therewith on the person. So it's the service.
Mr. Chair,
They require search
Mr.
warrant.
Chair,
They
if
require
you,
to do that.
before you have the search warrant issued, if the drone goes over the house, you establish probable cause, and you use that as the basis for the search warrant?
No, sir. Police cannot utilize a search warrant for any law enforcement purpose. Cannot utilize a drone for a law enforcement purpose absent a search warrant unless one of the carve-outs that is in that statute is met. This would in no way affect the requirement that a search warrant is obtained. What we're talking about really is notice to the person being surveilled. It's clarifying that they don't have to give immediate notice.
Well,
they have this time period to provide notice.
You don't quibble with the notion that there ought to be some good cause. I mean, what I hear you saying is, look, if we're going to use a drone for this purpose, we got good cause not to share it with the subject of the search warrant. So why not put that in?
There wouldn't be a problem if the authority was granted to the magistrate issuing the warrant at the same time. I can express the way it came up with our agency is we were utilizing a confidential informant at a time to buy narcotics from an individual, not marijuana, but a heavy narcotic, and they were hiding it in frankly, we believed their neighbor's property, but we didn't know where. And we didn't want to get a search warrant, serve it, and have to execute it and notice the person while the informant was on scene. It would have endangered the informant, it would have identified him, and it would have put the resources at risk.
I think in order to advance the bill, just if I am correctly gauging the pulse of the committee, it might be a good idea to attach the amendment that Steve just agreed is an important good cause protection. We can work out maybe some of the logistics if this bill moves on, but that would be my suggestion, is that we attach that amendment.
I certainly would be agreeable that, I only wanted to clarify that I would think it would need to be the initial person issuing the search warrant that would need to find that good cause and institute the delayed notice. Otherwise, it could be an issue.
So would that not be an important requirement that maybe we could put into the requirements necessary to get a search warrant to use a drone? That there be good cause not to share it with, not to serve it for that period of 10 days?
You could put upon a finding of good cause by the magistrate may permit this delayed service for a period of X days. Then you could have the same language that it could be extended by a circuit court judge. That would certainly work.
Yeah, not the, okay.
If we change it to
Right.
judicial
But you just
officer,
move
like was
states.
in the original language, then you don't have to go to circuit.
Or you,
court.
okay. All right. Senator Deeds or Senator Peterson, you want to move that amendment? Senator Deeds moves the good cause amendment. Is there a second? Seconded. All in favor of adopting that amendment signify by saying aye. Aye. All opposed? Okay, that good cause amendment is attached to the initial 10 days. Senator Stewart.
Thank you, Mr. Chairman. And I have to admit I'm confused, which happens to me a lot. But if you read the statute in subsection B, it allows you only to use a drone in the execution of a search warrant. So if we are using a drone in the execution of a search warrant, which seems to me is at least a simultaneous act, why would we delay serving the search warrant on that person? I just don't understand that.
I certainly understand your concern, but keep in mind, this is very unique. We've created a requirement for using drones, and again, we're not impeding into that person's home. We're not using any sort of devices to hear or to create some better way of vision. We're flying a drone over top at however many hundreds or thousands of feet. But again, if you have to, you essentially would be required to knock on the person's front door to hand them a copy of the search warrant. If that were to be the case.
But Mr. Chairman,
Senator Stewart.
You're not helping me, because if you say you're flying a drone hundreds of feet above the house, how is that you're using a drone to execute search warrant, which is all you're allowed to do, is to use the drone to execute the search warrant. It's all the statute allows.
Essentially, that is the execution. When you lift the drone into the air, when you start surveilling the property, that is your execution. That is the execution of the search warrant, flying the drone over top of the property. The entire point is to surveil, not to actually search.
Okay. All right.
I'm not following.
I'm sorry, if I could just briefly respond. There are other carve-outs, so this isn't something unique. For instance, the use of the tracking devices, or even when you're looking for financial records or anything to that sort, you don't actually disclose the issuance of the search warrant to the target. You provide the search warrant to the phone company. You provide the search warrant to the banking institution, but no one ever tells the provider for some period of time.
So would this permit, in addition to thousands of feet, would this permit you to use a drone to, look in all the bedroom windows?
I guess if that were permitted at all, but these are really questions that would have to be. I guess if you had I guess maybe it would be, because if you had probable cause to use the search warrant, you have probable cause to enter their home. So there wouldn't be any sort of.
Mr. Chair,
Senator
I'm going to put this bill out of its mercy, okay? You can go get a search warrant, knock on someone's house and serve it. And if you're not willing to do that, then in my opinion, you shouldn't have the search warrant in your hand. So I don't think this is ready for prime time. This would be a huge invasion of the Fourth Amendment, so I moved to PBI the bill.
All right.
Mr. Chairman.
Senator Stewart.
I agree with Senator Peterson. What it appears to me is that this is a bill to allow the use of drones for surveillance versus execution of a search warrant, and that really concerns me. And I think it's a huge violation of our constitutional rights. So I'd second that motion to PBI.
Delegate Brewer, you want to close real quick?
Just some food for thought, and I see the direction of the bill, so I'll be brief, but I think this is something that we seriously have to look at the future of technology and how we use it in law enforcement, and that's what this bill attempts to do. I think there's, the drone industry is growing leaps and bounds, and people are already using, obviously, drones in communities very openly, and so therefore I think at some point we will have to address this, and I think maybe at a later time we might be able to do that.
Well, I think that you have introduced a subject that we're going to be talking a lot more about. So it's been valuable. Motion has been made, properly seconded to pass the bill by indefinitely. The roll is open.
Ayes 12,
Bill
noes
is
3.
Passed by indefinitely.
Thank you.
Thank you. Delegate Leftwich.
Thank you, Mr. Chairman. Which one you want to handle first?
Let's, 2303, is that the first one?
I've got that in front of me.
All right, Delegate, I mean, you and I have talked briefly about this, and you know that we maybe took a different approach in handling Senator Cosgrove's bill. I think that there probably is some middle ground that we can reach, but in order to get there, I would suggest that we need to conform your bill to Senator Cosgrove's bill, and between you and Senator Cosgrove and perhaps a couple of us, we can see whether we can hammer out the differences. Is that okay?
Plead no contest to that.
Pardon me?
I plead no contest to that motion.
We'll work on it. No, it does not need to go to finance. Motion has been made to conform and report.
Ayes 15, no 0.
Okay.
And you have another?
Yes, sir. I think 2289, is that on today's docket?
Is it? Yes, it is.
Okay.
All right. I think this is a great idea. Go right ahead.
Okay, so, Mr. Chairman, I would categorize this as a judicial efficiency bill. So if you have a matter pending in General District Court and you want to increase the damages, you can transfer it to circuit court. If you're in circuit court and it becomes a matter that the General District Court has jurisdiction over, then the circuit court could transfer it to the General District Court without having to take a non-suit or a dismissal without prejudice. That's the bill.
Okay. Anybody have any questions of the patron? Anybody in the audience wish to speak in favor of or in opposition to the bill? It's been moved and seconded that the bill be reported.
Thank you, Mr. Chairman.
Ayes 15, no 0.
All right. Thank you, Delegate Leftwich. We've got a couple of other bills. Delegate Hope is not here. All right, without objection, that bill will be passed by. Yeah, he's busy. We've got Delegate Thomas's 2142. This, have we not dealt with this?
Not yet, Mr. Chairman.
All right, Senator Stewart, this is identical to your bill.
Yes.
Senator Stewart.
Mr. Chairman, this actually allowed us to or DGAS, I'm sorry, the ability to develop some newer training standards for school protection officers.
It's identical to your bill.
Identical to my bill, which
gonna move
passed
to report?
committee in the Senate. Move to report.
All right, it's been moved and seconded the bill be reported. And last, we have House Bill 2748, which is the tobacco products bill, similar to Senator Norman's 1727. And I think that what we need to do is conform this to, well, actually, we need to, Senator Norman's bill, two differences. Senator Norman's bill exempted active duty military. Is there a motion to add the amendment to Delegate Stolley's bill to exempt active duty military?
Just conform to Norman? No?
All right, it's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? And the second difference, and it's the reason I was not going to suggest that we conform, is that the House bill allows a person under age 21 to deliver tobacco products. And it would be my suggestion that we leave that in the bill. All right, the bill is before us. Anybody here in opposition to the bill? Yes, sir. Step right up. We're not going to relitigate this bill.
No, I promise I'll be short. Thank you. I'm Brian Donahue with the American Cancer Society. Most people are probably surprised to hear that the Cancer Society is against this bill. Legislative intent of the bill, great. We are all for it. But the actual bill, the underlying bill, is not going to accomplish what you want it to accomplish. The total emphasis of the bill is punishing the youths that buy the product. Currently, the majority of this law is on the books. 18 and under, you cannot buy tobacco products. 24,000 high schoolers smoke cigarettes. So it's not working. There's no enforcement. The reason there's no enforcement is because we don't have retailer licensing for tobacco products. So we don't know which retailers are, did you? I'm sorry, I thought you had a question.
Nope.
Okay, so our opposition comes in, it's a missed opportunity. We would like to reach out to the patron and say, if you're willing to work with us in the off-season to create a bill that's got real teeth that can really address this problem. 20% of high schoolers are now vaping. This is expanding a product and a problem in our schools. This unfortunately is not going to solve that problem. It's a feel-good bill, but it's toothless as it stands. Thank you.
Thank you. Anybody else wish to speak? Bill is before us. Is there a motion? There's motion properly seconded to report the bill is amended. Roll is open. All right. That
Ayes 11, noes 4.
bill reports. I apologize. I realize that on Delegate Thomas's bill, I may not have afforded an opportunity for those who wish to express their opposition to stand up. I would welcome that. If you all want to come up and say something, just as a courtesy to you, if there's a desire by members to reconsider it, we can certainly do that. But my apologies for not acknowledging you.
Thank you. I appreciate it. Mr. Chairman, members of the committee, Nikki Zamosny, I'm the Assistant Secretary of Public Safety and Homeland Security. We do oppose Senator Thomas's School Protection Officer bill. I have someone here from the Department of Criminal Justice Services who can speak to some of the technical issues if you have any questions. But we feel confident that our school resource officers and school security officers provide a level of protection to our schools now, and we don't feel comfortable creating a new category where the training is not going to be consistent. We think that that could create a lot of issues. So thank you very much.
Thank you. Yes, sir.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We share the same concern about the standard of training. We know that there's a move to determine that school resource officers need some specific training that's more tailored towards the school situation. We think that anyone, school security officers and anyone else, should get that same level of training. Thank you.
Thank you.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. I'm with the Coalition to Stop Gun Violence, and for the reasons stated here and to not keep you longer than you need to be here, we oppose the bill. Thank you.
Thank you, Lori. All right. All right, unless there are any motions, we're finished. The committee will rise.